over torture was not a dispute between people, on one side who said we should follow the law, and on the other side, people who said we shouldn't follow the law. Everybody claimed to be following the law, including the Bush administration officials who authorized torture. So really, I'm hoping that in questions for the record, the committee will be able to get Judge Gorsuch to speak more specifically about the role he envisions for the judiciary in the context of national security.
Hope springs eternal, but don't hope too much. He might. I was thinking of what Miss Massimino. You'd think with my Italian background, an Italian mother, I could pronounce that correctly, but you'd raise the action of the Justice Department, and I'm very concerned that he declined to answer any questions regarding his role there, what his views were on it, even though documents indicate they helped the Bush administration justify torture, indefinite detention, and warrantless surveillance. Should we be concerned about that work?
I think you should. And, that period of time in our history was so important to our democracy. And we talk a lot here about the law, but, it turned out that the lawyers were actually, in many respects, even more important than the law, because they were the ones who were trying to interpret what the law meant. And, there were other people at that time, government lawyers, who were extremely troubled when they found out what was going on, and they tried to stop it. And from the record that we have here, it does not appear that Judge Gorsuch was one of them.
Well, it is a great expansion of executive power that many of us question. And in my remaining time, I know Mr. Perkins, I listen and know about the story of Luke. And, I'd hate to have been in your shoes, but I think I would have felt the same way. But we found out yesterday Judge Gorsuch's application of the Individuals with Disabilities Education Act was turned down by the U.S. Supreme Court. They said the standards are markedly more demanding than the standard that Judge Gorsuch created in your son's case. How did you feel about what did you think when you heard the Supreme Court?
I was very happy that they reversed a trend that clearly Judge Gorsuch and the 10th Circuit had been part of to water down the standards for progress such that they were of minimal practical benefit. Because even with these very watered-down standards that were part of Luke's education program, he was only meeting 25% of his objectives. But I really appreciated the fact that that Judge Roberts or Chief Justice Roberts used words like every child should have the chance to meet challenging objectives. That indeed is the case, and when that can happen, even a child with severe disability can make tremendous progress.
Thank you very much. Thank you, Mr. Chairman. And I thank the senator from Hawaii.
Senator Hirono, sorry.
Thank you, Mr. Chairman. Thank you all for being here. Mr. Perkins, yesterday was a good day for your family with the Supreme Court's decision. IDA is what I would call remedial legislation meant to protect a class or a group of people, in this case, people with disabilities. And generally, remedial legislation, not even generally, remedial legislation should be broadly interpreted to effect its purpose. So when you were before Judge Gorsuch and you saw that opinion, do you think that Judge Gorsuch did, in fact, do that, broadly interpret IDEA to effect its purpose in your son's case?
Absolutely not. In fact, he did the exact opposite. He took precedent that, frankly, in light of yesterday's decision, was already inappropriately narrow or restrictive, and further restricted that interpretation, such that I really wondered why would Congress even bother if that's really what IDEA meant.
So do you think that if Judge Gorsuch had looked at the legislative history, perhaps, of what was behind IDEA, that he may have issued a more expansive ruling than what than his dissent showed?
I would hope so. I know that his picture of what he felt the law said was a huge distortion of what the actual intent was. And so I would have hoped that if he had looked into it some more, he might have been able to see that he had reached a wrong conclusion and maybe backtracked in his judicial reasoning and come to a more appropriate conclusion.
So I understand that your family had a lot of resources. You are a doctor. You had parents who helped you. You did different things to accommodate the needs of your child. And I'm wondering whether, as you sat there before Judge Gorsuch, and knowing that your family is one of literally thousands, hundreds of thousands in our country who have children who look to the IDEA for the kind of educational support that they required, what did you think about all the families who don't have the kind of resources that you have, and what Judge Gorsuch's ruling would have done to their ability to do the best for their child with disabilities?
Actually, that is probably one of the most frequent thoughts that we had through this whole legal process, is just realizing how overwhelmed we were with all of the resources, financial, family support resources that we were blessed with. We were overwhelmed, and to think that the people out there, I mean, many of my patients, I think, how in the world, if they had had Luke in their family, could they have done this? It's having a child with a severe disability is completely overwhelming, and sometimes it may seem impossible. I mean, even for us with our resources, we felt at many times that this may be impossible because the law apparently isn't on our side.
Thank you. With the brief time that I have left, I'd like to ask Mr. Calamine. We have concerns about how Judge Gorsuch would rule in cases relating to workers' rights and unions, and I refer to his decision in NLRB v. Community Health Services. Is that a decision you are familiar with?
Yes. Now that I've looked back at my
familiar
notes here.
enough.
A little bit.
So he had a dissent there that really disadvantaged these workers who had been illegally denied longer hours, and it affected their pay, so they had to get another job. Would you share your thoughts on Judge Gorsuch's dissent and his overall judicial record on workers' rights, really briefly?
Briefly, the dissent in that case involved, I believe, Judge Gorsuch saying that these hospital workers who had been unlawfully, their hours had been reduced unlawfully, they went out and got other jobs to try and make up for their loss of income. What Judge Gorsuch wanted to do in his dissent was to subtract the money that they earned from those outside jobs from the total back pay award, which meant, it does not recognize, it's an example of not recognizing what life is like for somebody working for hourly pay, trying to make ends meet. Just going out and getting another job itself is a big problem. You've got new schedules, you've got family issues.
So my question really was whether you think that on the Supreme Court he would continue to
that is the
a very
concern.
restrained view of workers' rights.
That is the concern we have, that the workers' perspective isn't going to see a fair shake here.
Thank you, Mr. Chairman.
I have one question, then I'll turn to Senator Feinstein, and when she's done, we'll bring on the next panel. Judge Kane, I bet this is the first time since 1977 since you've been before this committee. Is that right?
That's correct, Senator.
This is, you've been a judge for 40 years, but before that, you were a public defender. When you were a public defender, did you adopt every position of your client?
Well, I represented a number of murder defendants, and I didn't agree with them on that.
So you can represent somebody without agreeing with them, just like Judge Gorsuch, when he was in the DOJ, could also represent his superiors as their counsel.
Absolutely.
Okay, Senator Feinstein.
Your Honor, I would just say, this is just my view, that for those in government, the standard has to be a little bit different. You have to do what's right. And this goes up even to the launching of a nuclear bomb. I asked someone who was in a position once, if you thought the president was absolutely wrong in what he was doing, would you deny a launch? And the answer was no. And that caused me to think about the obligation that we have as service in government to do what's right as far as we know it. And I think that even affects attorneys who have bosses, because in this case, lives are a real problem. In any event, I would like just quickly, and then to put in the record, the Supreme Court's opinion in the IDEA case. And I'd like to just quote a few lines. To meet its substantive obligation under IDEA, a school must offer an educational improvement plan reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. The reasonably calculated qualification reflects a recognition that crafting an appropriate program of education requires a prospective judgment by school officials. So I would like to put that in the record, if I may, Mr. Chairman.
Without objection, so ordered.
The second thing, in response to my friend and colleague who spoke about the Detainee Treatment Act, Senator Graham, I was McCain's co-sponsor on his bill, and I would like to read from his statement on the floor on February 13th, 2008. And in this, he makes clear that his view of the Detainee Treatment Act in 2005 outlawed waterboarding. He says, and I quote, "I stated during the passage of that law that a fair reading of the prohibition on cruel, inhumane, and degrading treatment outlaws waterboarding and other extreme techniques," end quote. So I would ask that this statement be part of the record as long, and also the opinion in this case.
Yeah. Without objection, so ordered. Now, should I go to Senator Blumenthal?
Yes.
Senator Blumenthal.
Thank you, Mr. Chairman, and thanks to the members of the panel for sharing your insights and experience with Judge Gorsuch. I have a question for Mr. Calamine, but others are free to answer it as well. As you know, the importance of our consideration here is not only the results. In fact, even more important than the results, the judge's method of reasoning, his approach to analysis in cases. And a couple of cases I think are illustrative in Compass Environment, Inc. versus OSHRC. Judge Gorsuch voted to overturn a fine that was imposed by the Department of Labor against a company whose failure to properly train a worker actually caused a death. In Trans Am Trucking versus Administrative Review Board, as we all know now from the discussion that took place when he testified here, he voted to reverse the judgment of both an administrative judge and the Department of Labor, which held that a truck driver had been improperly fired in violation of federal law. Truck driver abandoned his truck, sub-freezing weather, when the heater in his cab failed to function, and did so, in essence, to save his own life. I wonder if you could comment about the purpose of the laws that he was interpreting here and why you have reservations about his analytical approach, his method of reasoning in approaching these laws, and other cases that have the same effect. And I open the same question to others on the panel.
Thank you. So the purpose of the laws in the two cases that you just mentioned, Compass Environmental and Trans Am Trucking, the purpose of those laws is to protect workers' health and safety. And one of the most alarming things about one of those cases is Judge Gorsuch describing those purposes as ephemeral and generic. In other words, there's not enough concrete there to allow those purposes to guide how we interpret these laws. So instead, we turn to things like the Oxford English Dictionary, which he did in that particular case. Another concern from the other case, from Compass Environmental, is his description of OSHA's powers as being remarkable. And in that case, the worker had been electrocuted to death, and the remarkable power imposed by OSHA was a $5,550 fine, just a $5,500 fine on the employer. And that is described as remarkable. And that is a concern because workers in this country rely on that agency and other agencies to enforce their rights every day. And we have come to rely on those interpretations. We want to know what the law is. We don't want the second edition, 1989 Oxford English Dictionary to suddenly be pulled out to change that law. And that's what almost happened in Trans Am Trucking, a rewrite of the law.
Any other members of the panel?
If I might, Senator.
Sure.
I'm comforted to hear that you specifically note that we're not going to just look at the results of cases in judging Judge Gorsuch, because obviously he's been on the bench for 10 years, so we're focused on certain cases in which he may have ruled against certain workers, but there are a number of other decisions that I believe the committee is aware of, where he ruled in favor of workers. And I believe that the approach he applies in all of those cases, irrespective of the result, is to look at the text as was passed by Congress and apply it fairly to the facts before him. And I believe that it's that process that does not change. It's the results that change based on, obviously, the facts of the case before him as applied to the statute.
And the reason I asked about the reasoning and analytical approach is precisely the answer that has just been given. To regard a worker protection statute or the concept of health and safety as ephemeral and generic is, in my view, a gross understatement of the purpose of these laws, which are basic to people who leave their homes in the morning, say goodbye to their families, expecting to come home at the end of the day without having been injured, maimed, or killed. That's the purpose of these laws. That purpose is not generic or ephemeral. It is urgent and important. And Mr. Calamine, I think, well stated the reservation I have based on his use of that language. And by the way, I've been here for 7 years. I've never heard any United States senator quote the Oxford Dictionary for the meaning of a term. Never. Not once. And yet Judge Gorsuch uses it very, very abundantly in his opinions to seek a definition for how he's going to apply a statute. That's not a real-world approach to health and safety, and it concerns me. And that's why I asked the question. But it's not the result alone. In those cases, I was concerned about the result. He probably has ruled for individuals, and we've been throwing around this term, the little guy. It doesn't matter whether it's a big or little person or group of people. It's more the concept of preserving worker safety that is important. Thank you.
You bet. Thank you, Senator Blumenthal. Thank you all for your presentation. More importantly, for your preparation and for informing the committee. Thank you very much. And will the second panel come? But while the second panel come, and please don't sit down until I swear, but I want to inform the members.
Swear you in, you mean? You're not just going to swear.
Yeah, swear in, yeah. Here's what I'd like to have the members think about. We will not get through this panel presentation at 12:25 is when the vote starts, so I think we're going to go with this panel till 12:35, and then we'll recess, and I'll vote at the end of the first vote, and then vote on the second vote immediately. So that means we'd probably reconvene this panel about 1:05 or 1:10 in that period of time, and then we'll have the rest of the panel presentation and the questions, and then we have yet one more panel, I believe one more panel after that. So do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. I'm going to do something that I forgot to do, and it was very wrong of my not doing it. I didn't say anything about the last panel individually. Jeff Lampkin is a founding partner of Molo Lampkin, and he clerked for Justice O'Connor. Heather McGee is president of Demos. Is that how you, Demos? Okay. Professor Lawrence Slocum is a Carmack Waterhouse professor of law, Georgetown. Fatima Goss-Greaves, senior vice president for program and president-elect of the National Women's Law Center. Professor Jonathan Turley is on TV all the time. That doesn't say that here, but I can say it. Is the J.B. and Maurice C. Shapiro Professor, Public Interest Law, George Washington U. Pat Gallagher is Director of Environmental Law Program, Sierra Club. Karen Harnan is Executive Director, the National Federation of Independent Business, Small Business Legal Center, and Eve Hill is partner with Brown Goldstein Levy. She previously served as Deputy Assistant Attorney General for the Civil Rights Division from 2011 to 2017. We'll start there, and we'll go until we see how this vote goes.
Thank you, Mr. Chairman. Ranking Member Feinstein, members of the committee, for the opportunity to speak to you about Judge Gorsuch. Since clerking for Justice O'Connor in 1992, the honor of arguing 23 cases before the U.S. Supreme Court. Many of those as an assistant to the Solicitor General, first under Seth Waxman, who was President Clinton's Solicitor General, and then later under Ted Olson, who was President Bush's. I've known Neil Gorsuch, Neil as I've always known him, as a colleague and a friend for more than 20 years. My wife, who's here today, has known him even longer because she went to law school with him. I like to think I helped recruit Neil to Kellogg Huber after his Supreme Court clerkship and his time at Oxford. I think I may have edited the first brief he ever wrote as a young lawyer. I understand he's improved substantially since then. And I can tell Senator Sass that he'd never once used the word bigly in a brief. Of course, from the outset, it was always clear to all of us that he was not only smart and thoughtful and a great writer, but he had great judgment. In both a literal and figurative sense, he had gray hair from the beginning of his career. But I want to speak to you about something other than Judge Gorsuch's legal acumen. I want to speak to you about his kindness, his compassion, his generosity of spirit as a person, and why those values are integral to who he is and what we should expect to him from the bench. Since I first got to know Neil many years ago, he's been one of my dearest friends. We both have 2 daughters, his a bit older than mine, and he's always been there for me to listen, to advise, to commiserate about the trials and travails of the often difficult project that's being a parent. I have vivid memories of standing in Neil's backyard in Colorado after he became a judge, talking about what then seemed to me about a very difficult moment. As we spoke, we scooped up horse manure while his family's pet goat Nibbles tried to ram the judge. I honestly never understood what they saw in that goat. Neil's kindness resonated throughout his family, excluding the goat, of course. His daughters were always so sweet to my children, even though my kids were considerably younger. I remember Neil and his kids repeatedly leading one of my kids through one of life's adventures by the hand, whether trying to balance on skis or trying on hats at a department store. If something happens to me and my wife, Neil stands in line to inherit my children. Some people say, if you want a friend in Washington, get a dog. Those people never got to know Neil Gorsuch, his wife Louise, or his family. Simply put, Judge Gorsuch is a thoroughly decent and kind person. So why does that matter to this body as it's considering his nomination? As a former colleague of mine from the Solicitor General's office told me, if you have someone who's that good a person, it means he listens. It means he truly hears. It means he can be persuaded. That is, to my mind, the most essential attribute for a Supreme Court justice. The Supreme Court has an argument calendar, but the printed list of cases and counsel the court prepares for each session is called the hearing list. It's the chance for people to be heard. When the Chief Justice calls each case, he says, "We'll hear argument in case number," and then he gives the case number and the case name. The key words there are hear argument, not just have argument, but hear it. I know that everyone who appears before Judge Gorsuch, before Neil, will be heard, genuinely heard, regardless of who they are, who they represent, their position, or the nature of the controversy. His kindness and his humility make him place an extraordinary value on listening to the lawyers, to his colleagues, and to those with backgrounds different from his own, who may come at the matter from a different angle or insight born of different experiences. I've heard a lot of speculation over the last few days and months about how Judge Gorsuch might rule on this matter or the other. I don't know how he might rule. I don't think he knows. These are often really hard cases. That's why they get to the Supreme Court, because they're hard, because the judges disagree. But I do know that Judge Gorsuch will struggle with those hard cases. He will immerse himself in the law, in precedent, in the context, in the record, in the briefs, in the arguments. He'll listen to the litigants, listen to his colleagues, to history, to experience and its lessons, and he will decide the cases based on where those things lead him at the end of the case, based on the force of the better argument, not based on a pre-existing intuition that may predate the case's beginning. That, I believe, is precisely what we should all hope for from our judges and justices. That's true whether you consider yourself a Democrat like me, or a Republican, or an independent. If the Senate believes that as well, I believe that Judge Gorsuch should be confirmed. Thank you.
Ms. McGee.
Chairman Grassley, Ranking Member Feinstein, members of the committee, thank you so much for the privilege of testifying here today. My name is Heather McGee, and I'm the president of DEMOS, a public policy organization working for an America where we all have an equal say in our democracy and an equal chance in our economy. What's at stake is not just the critical issues that you've heard about over the past few days, but the way that we, the people, make decisions about all of the issues that we face as a nation, and whose voices are heard in that process. Judge Neil Gorsuch has the potential to be the deciding vote to destroy the few remaining safeguards against big money corrupting our politics completely. His troubling record on money in politics requires this committee to reject his nomination to the U.S. Supreme Court. I'd like to make 3 basic points today. First, that the way that we fund our campaigns in the U.S. enables wealthy individuals and institutions to take their economic might and translate that directly into political power. Second, the Supreme Court's activism in striking down democratically enacted safeguards is what has brought us to this perilous place in our history. In the world's oldest democracy, nearly 9 out of 10 Americans have lost so much faith in our system that they think a total overhaul is needed. Senators, we are near a breaking point. 9 out of 10. It's hard to imagine things getting worse, and yet the prospect of a lifetime seat for Judge Gorsuch has given us a glimpse. Fortunately, there is an overwhelming bipartisan consensus supporting pro-democracy reforms, even though Neil Gorsuch is far outside of that consensus. Your constituents want you to stand up to big money, and your vote on this pivotal Supreme Court seat will be one of the best chances you will ever have to do so. Leading political scientists have concluded that our government now resembles a plutocracy more than a representative democracy. Just 25 individuals pumped more than $600 million into last year's elections. Less than 1% of the population provides the vast majority of the funds that determine who runs for office, who wins elections, and what issues get attention from elected officials. They say that he who pays the piper calls the tune, and so, of course, our public policies are skewed towards the wealthy and away from working-class families and people of color, who remain massively underrepresented among top donors and in the halls of power. The role of the Supreme Court in creating this crisis can't be emphasized enough. Last week, Demos released a report calculating how much extra money has flowed into politics because of Supreme Court rulings striking down campaign finance laws. We found that in the 2016 election cycle, court decisions were responsible for nearly half of all the big money spent. Still, it's not too late to reverse course. The Roberts Court's campaign finance rulings have been 5-4 decisions in which the majority's basic assumptions about politics have been proven false, including the idea that so-called independent expenditures are actually independent of candidates and therefore can't be corrupting, and that disclosure laws would be effective. With a Supreme Court that was responsive to the facts rather than ideology, we could end the super PACs that the court created and begin to restore our democracy. But Judge Neil Gorsuch would have been with the majority in Citizens United. His overall record puts him to the right of Scalia, and on the question of money in politics, he would take us even further down the Roberts Court's extreme path. Judge Gorsuch has had 2 directly relevant cases. In Hobby Lobby, he voted to expand First Amendment rights for corporations, building on Citizens United's troubling logic. In Riddle v. Hickenlooper, he went out of his way to signal openness to applying the harshest possible standard of review to campaign contribution limits, which would deem a wealthy donor's check worthy of more constitutional protection than the court has consistently offered for our most precious right to vote. Judge Gorsuch was given an opportunity in this room to distance himself from one of the most unpopular court cases in American history, and he failed to do so. Thankfully, outside of the Beltway, this is not a partisan issue at all. 91% of President Trump's own voters thought it was important that he appoint someone to the Supreme Court who'd be open to limiting big money in politics. 70% of Republicans say that Congress should reject any nominee who, quote, will help the wealthy and the privileged wield too much power in our elections. The American people are demanding change to a political system that favors the already wealthy and well-connected. So we urge you to vote against Judge Gorsuch's nomination and to tell your constituents that a key reason you did so was to stand with them over big money. They will thank you, and I thank you.
Thank you very much. Professor Solem.
Thank you very much, Senator. Ranking Member Feinstein. I voted for you in 1992, and it's a pleasure to appear before you today. My statement concerns an aspect of Judge Gorsuch's judicial philosophy, originalism. And over the course of this hearings, I think we've learned several things about originalism, and there are still some things I think that might be cleared up. What is originalism? It consists of three basic ideas. The first idea is that the meaning of the Constitution should be its original public meaning, the meaning of the words and phrases in context to we the people. The second idea is that that meaning is fixed, not that the law is fixed, but that the meaning of the words is fixed at the time they're written. And the final idea is that that original public meaning should constrain what judges do. That judges, the president, the members of this august body are all bound by the original public meaning of the Constitution. Over the course of the past 3 days, we've learned some other things. We've learned that there are a number of myths about originalism, and I think that those myths have, for the most part, been cleared up. Originalism does not ask the question, what would Madison do? A very silly question when we try to apply the Constitution to modern circumstances. We've learned that the words of the Constitution can be adapted to new circumstances. At the time the Constitution was adopted, California did not exist. It was not a state. But we have no problem concluding that nonetheless California is now a state and entitled to 2 senators in this body. We've learned that Brown v. Board, one of the most important decisions in the history of the Supreme Court, is not inconsistent with the original meaning of the Constitution. As Judge McConnell demonstrated in 1995, Brown v. Board was required by the original meaning of the Constitution. And we've learned this very clearly, that originalism is not inconsistent with precedent. What I'd like to say today, most importantly, is that originalism is in the mainstream of American jurisprudence. Originalism in the mainstream of American jurisprudence because throughout our history, for the most part, with some important exceptions, the Supreme Court has been an originalist court. But originalism is in the mainstream for another reason. Originalism can and should be endorsed by both Democrats and Republicans, by progressives and conservatives. This point is important to me personally. I'm not a conservative. I'm not a libertarian. I'm not a Republican. But I do believe in originalism. Why is that? It's because I'm convinced that giving power to judges to override the Constitution, to impose their own vision of constitutional law, is dangerous for everyone. If you're a Democrat and you know that the next justice to the United States Supreme Court will be appointed by a Republican president, and confirmed by a Republican Senate, would you prefer that an originalist like Judge Gorsuch be appointed, or would you prefer a conservative justice who's a living constitutionalist, who believes that their values are an appropriate ground for modifying or overriding the constitutional text? There's a final reason that originalism is in the mainstream. The Supreme Court has never claimed the right to override the Constitution. There are cases where the Supreme Court did, in fact, depart from original meaning. But in all of those cases, the Supreme Court either strained to make its decision consistent with the text or ignored the text altogether. I support Judge Gorsuch's nomination because he is an originalist.
Thank you, Professor Solem. Ms. Graves.
Thank you, Senator Ranking Member Feinstein and the committee. My name is Fatima Goss-Graves, and I am Senior Vice President for Program and President-elect of the National Women's Law Center. Since 1972, the Center has been involved in virtually every major effort to secure and defend women's legal rights. I thank you for your invitation to testify today and ask that my full written testimony be submitted. Over the past few days, Judge Gorsuch has talked a lot about how he follows the law rather than his personal views or his feelings, and that he applies the law to facts. But a review of his record shows that time and again, his approach to the law gives the benefit of the doubt to employers, to politicians, to other powerful entities, rather than the vulnerable individuals who rely on the law for protection. And time and again, this approach disadvantages women. If you take the case of Betty Pinkerton, an administrative assistant whose sexual harassment claim was dismissed, Judge Gorsuch ruled against Ms. Pinkerton on the grounds that her failure to report the harassment she faced for all of 2 months was unreasonable. During that period, she had to listen to her boss ask about her breast size, ask about her sexual habits, and under Title VII, these sorts of remarks only become a pattern of harassment as they add up over time. If she complained too early under Title VII, she'd have no claim. And waiting 2 months, under Judge Gorsuch's approach, again, she had no claim. This is an approach that ignores the workplace realities that the law is designed to address and the very nature of workplace harassment. Or if you take the Hobby Lobby case, in which a corporation challenged the Affordable Care Act's birth control benefit, which requires health insurance plans to provide birth control without cost sharing. Access to contraception means for women the ability to plan their lives, to plan their futures, and the birth control benefit relieves women of a steep financial burden, which can run as high as $1,000 in upfront costs. Judge Gorsuch joined the 10th Circuit holding under the Religious Freedom Restoration Act that an employer's religious beliefs could override an employee's right to birth control under the Affordable Care Act, including an especially extreme holding that promoting gender equality and public health, the very goals of the birth control benefit, were not compelling government interests. His concurring opinion was stunning in its refusal to even acknowledge the health impact and the financial burden on women who would lose insurance coverage under his approach. Ultimately, the case reached the Supreme Court, and unlike the decisions joined and written by Judge Gorsuch, the Supreme Court instructed that as a part of RFRA's balancing test, courts must consider the impact on women. Judge Gorsuch's record also shows hostility to the Constitution's protections of the most personal and intimate decisions, which is the basis for the right to birth control and the right to abortion. Yesterday, Judge Gorsuch declined to say whether Roe v. Wade was correctly decided, merely acknowledging that it is actually precedent of the court. And he refused to answer key questions about other areas of the law that accord to women's lives. When he was questioned about letters from former students who claimed that he had suggested companies can and should ask women and only women about their pregnancy plans and their family plans, even in explaining this incident, Judge Gorsuch shockingly refused to acknowledge that such behavior would violate Title VII. And to be clear, statements like these are wildly at odds with the very letter and the very purpose of Title VII and the Family Medical Leave Act. Finally, we reviewed Judge Gorsuch's record against a highly unusual backdrop, including promises made by President Trump that his nominee would overturn Roe automatically and that he would be selected from lists approved by the Heritage Foundation and by the Federalist Society, a really highly unusual occurrence, to say the least. When you put these extraordinary promises together with the judge's record and his refusal to provide anything but platitudes about his judicial philosophy to this committee, there is only one possible conclusion, and it is that Judge Gorsuch should not be confirmed.
Thank you, Ms. Graves. And to the remaining witnesses on the panel and the members of the committee, we are about halfway through a vote, and we are all going to need to take a recess to go vote. So what we will do is also give a few extra minutes to that recess so that folks can get a bite to eat if they can. And we will, in fact, do we have two votes?
I'll be back here about 1:10 to take up the gavel again.
We will recess until 1:10 and continue our deliberations at that point. The committee's in recess.
I will abrogate the recess, but I want to explain something. This vote that we thought would get 2 votes done by 1:10, the first vote's not going to end until about 1:20. So I'll have a chance to get through the 4 people testimony, and then if we have hopefully a Republican Democrat votes and they're over here, so I can go finish voting. If you wonder about the importance of voting for me, I haven't missed a vote since 1993, so that's about 7,900 votes without missing a vote, and I don't intend to miss another one. Professor Turley.
Thank you, Chairman Grassley and members of the Senate Judiciary Committee. It's an honor to appear before you today to discuss the nomination of Judge Neil M. Gorsuch for the United States Supreme Court. I believe that a nominee should be extraordinary to merit the distinction of being one of 9 on our highest court. I should state at the outset that I do not agree with all of Judge Gorsuch's legal views. However, I believe that Judge Gorsuch to be an exceptional choice for the court. While many have focused on replacing a conservative with another conservative, the primary concern should be to replace an intellectual with another intellectual. Judge Gorsuch is precisely that type of nominee who has the intellectual reach and vigor to sit in the chair of the late Antonin Scalia. One of the primary complaints regarding past nominees has been a lack of substantive writings or opinions on major legal issues of our time. Such individuals can make for good nominees. They do not make for great justices. Judge Gorsuch is a refreshing departure from that trend. He has a record of well-considered writings, both as a judge and as an author. So this is not a blind date. We have a very good idea of who Judge Gorsuch is and the type of justice he will be. In my written testimony, I focused on 2 aspects of the nomination. First, I've addressed the criteria often used to evaluate a nominee, and second, I've looked at the cases by Judge Gorsuch, and with a particular emphasis on separation of powers, agency review, and Chevron. Every president and senator has expressed a commitment to placing the best and the brightest on the court, though few would agree on the qualitative measures needed to guarantee that. Historically, the record is not encouraging, to be frank. Our respect for the court often blinds us to the fact that our justices have ranged from towering figures to virtual nonentities. To be blunt, we've had more misses than hits when it has come to appointments onto the court. Top candidates are often rejected due to writings and views that might attract opposition. The result is a preference for nominees with clean records that have no public thoughts challenging conventional theories, not even raising particularly interesting ideas. That is not the case with this nominee. Judge Gorsuch has actively participated in debating some of the toughest questions of our time. This is, in other words, a full portfolio of work at the various highest level of analysis. On the basis of all the criteria I discussed in my testimony, Judge Gorsuch is a stellar nominee. I realize that many do not welcome a conservative nominee any more than they welcomed a conservative president. However, President Trump has every right to nominate someone who shares his jurisprudential views. To put it simply, Neil Gorsuch is as good as it gets, and he should not be penalized for engaging in the policy and academic debates of our time. In my written testimony, I discussed some of his opinions. There are many, 2,700 or so. The jurisprudence reflects, not surprisingly, a jurist who crafts his decision very closely to the text of a statute, and in my view, that is no vice for a federal judge. The exception, as I talk about, is Chevron, in terms of the consistency of his views with those of Justice Scalia. There, we've seen a lot of discussion of cases, which I would be happy to go into. The confirmation hearings bring almost a mythical aspect to this process as people try to predict who a justice will be decades in advance. Of course, nobody knows that, except perhaps the nominee. And if history is any judge, even the nominee doesn't know that. These hearings often remind me of a story of Supreme Court Justice Oliver Wendell Holmes, who was traveling by train to Washington, D.C. when a conductor asked him for his ticket. Holmes looked in all of his pockets, and the conductor finally stopped him and said, "Don't worry about your ticket, Mr. Holmes. We all know who you are. When you get to your destination, just send us the ticket." And Holmes responded, "My dear man, the problem is not my ticket. The problem is, where am I going?" Most nominees are in the same position as Oliver Wendell Holmes. They're not quite sure where they're going. People of good faith can evolve on the court. I do not expect Judge Gorsuch to be a robotic vote for the right of the court. While conservative, he's shown intellectual curiosity and honesty that I think is going to take him across the ideological spectrum. But in conclusion, I would simply say, we're not looking for the best imitation or facsimile of Justice Scalia. We're looking for someone who can be an intellectual court on the court in his own right. That person, in my view, is indeed Neil Gorsuch, who just might eclipse his iconic predecessor. Won't be the same. He's going to bring something new. In the end, what I can say about Gorsuch's destination, unlike Holmes's, is that, well, I suppose they have this in common. He'll go where his conscience takes him. It might be a track to the left or to the right, but he'll follow his conscience. And I can't say what the final terminus will be, but it'll be exciting to watch. And it is therefore my honor to recommend the confirmation of the Honorable Judge Neil Gorsuch for the United States Supreme Court.
Thank you, Professor. Now, Mr. Gallagher.
Chairman Grassley, thank you for the opportunity to testify here today on behalf of the Sierra Club and its 2.8 million members and supporters nationwide. A Supreme Court justice holds considerable power over the laws which safeguard the very air we breathe and the water we drink, and the integrity of our democracy. Unfortunately, Judge Neil Gorsuch's ideology threatens both bedrock environmental law and the rights of American citizens to a fair and equal voice in our democracy. For these reasons, the Sierra Club respectfully opposes Judge Gorsuch's confirmation to the Supreme Court. Judge Gorsuch has displayed a consistent willingness to close the courthouse doors to citizens while holding them open for corporate interests. Think for a moment of the child in Bakersfield, California, struggling to breathe as a result of the oil and gas operations right outside her home and school, or of the family who may not be able to take their annual camping trip to the Wayne National Forest in Ohio because of fossil fuel drilling operations at that place, or of the families right here in Washington, D.C. who continue to suffer from the lead contamination of their drinking water. I presume that everyone in this room would agree that every single one of these people deserves access to the federal courts to remedy these wrongs. Unfortunately, Judge Gorsuch's writings and judicial record show that he would shut the courthouse doors on many of these people who want nothing more than to protect their air, water, public lands, and their families. In 2005, Judge Gorsuch authored an article in the National Review entitled "Liberals and Lawsuits," where he criticized those who seek to remedy injustices in the federal courts when the executive branch fails to do its job. While Judge Gorsuch has reportedly stated that he wishes this National Review article would just quote-unquote disappear, his judicial record continues to reflect this philosophy, as he has repeatedly denied environmental plaintiffs access to the courts, where citizens must jump through multiple, often insurmountable hurdles just to get inside Judge Gorsuch's courtroom. Corporations have been able to walk right in. Let me cite two examples. In 2013, the Sierra Club moved to intervene in a lawsuit that an off-road vehicle group brought against the Forest Service, challenging the closure of certain forest trails to off-road vehicles. The court granted us intervention, but Judge Gorsuch dissented, concluding that we should have been excluded from the case. Tellingly, neither the government, the off-road vehicle group, nor the majority of judges objected to our participation in that case. Second, in 2005, a coalition of citizens groups, including the Wilderness Society and the Sierra Club, challenged a Utah county's attempt to take over Red Rock wilderness areas that were managed by the Bureau of Land Management by claiming that they were county highways. Judge Gorsuch ruled that the citizens did not have standing to sue. They did not get into the courtroom. In an emphatic dissent to Judge Gorsuch's ruling, one that echoes my testimony here today, Judge Lucero, also of the 10th Circuit, stated, quote, "A citizen's right to protest and be heard on the supremacy of federal rules and regulations is ignored." Not only has Judge Gorsuch limited access to the courts, he has stated open hostility to the Chevron doctrine, a long-standing precedent of the Supreme Court that ensures scientific integrity is respected as our public servants implement clean air and clean water regulations. The Chevron doctrine ensures that the laws on the books are carried out by career public servants using the best available science. Here's the most troubling issue. Judge Gorsuch's opinion that Chevron deference violates the Constitution echoes the current White House's extreme anti-agency demagoguery. 1 month ago, Trump's senior advisor Steve Bannon gave a speech to the Conservative Political Action Conference in which he professed that a White House priority is the quote-unquote deconstruction of the administrative state. Trump's massive budget cut for EPA was the next hammer to fall. Sadly, Judge Gorsuch's ideology will further this agenda, hamstringing the EPA's ability to enact pollution safeguards and incentivizing corporate polluters to challenge the EPA at every turn, thereby forcing federal judges to second-guess agency scientists. In closing, we now stand at a precipice in history. How will we deal with climate disruption? How will we lift up our communities who lack access to clean drinking water and clean air? How will we leave a safe and livable future for our children? America cannot afford the appointment of yet another justice whose ideology disfavors citizens groups, favors corporate interests, and leads to the degradation of the environment and our democracy. This is why the Sierra Club respectfully opposes the confirmation of Judge Neil Gorsuch to the Supreme Court. Thank you very much.
Thank you, Mr. Gallagher. Now, Ms. Hardin.
Chairman Grassley, on behalf of the National Federation of Independent Business, I am honored to testify today in support of the nomination of Judge Neil Gorsuch to be an Associate Justice of the United States Supreme Court. NFIB is the nation's leading small business advocacy organization with hundreds of thousands of members across the country in every industry and sector. As the lead plaintiff in the historic challenge to the Affordable Care Act, NFIB versus Sebelius, NFIB understands firsthand the importance one justice can have on the ability of small businesses to own, operate, and grow their business. After reviewing Judge Gorsuch's articles, decisions, and public statements, we are pleased to see a judge who both applies the actual text of the law and the original meaning of that text at the time it became law, rather than changing it to fit his personal views and preferences. Specifically, small businesses are encouraged by 3 qualities Judge Gorsuch has brought to the bench. His opinions are clear and often provide bright-line rules. He has a deep respect for the separation of powers, and he has shown a willingness to tackle the difficult legal issues of our day head-on. Judge Gorsuch is not known for using ambiguous or broad language that fails to settle the question before him. Rather, his decisions provide meaningful direction for district court judges, as well as businesses and ordinary individuals who may be affected by that law moving forward. Like their larger counterparts, small business owners want and need certainty. They need bright-line, easy-to-understand legal standards. If small businesses don't know what is expected of them, what the rules of the game are, they may be hesitant to undertake actions that otherwise would help their business grow. Judge Gorsuch takes seriously his obligation to provide that clarity whenever possible. Judge Gorsuch also has demonstrated that he truly respects and seeks to protect the separation of powers among the branches of government. This is important because NFIB is concerned about what we see as the rising tide of regulation promulgated by unelected bureaucrats. This trend over the last 30 years contravenes the fundamental principle that only Congress, as the elected and politically accountable legislative branch, should be able to enact and change statutory law. When it comes to regulations, small businesses bear a disproportionate amount of the regulatory burden as compared to their larger counterparts. That is not surprising since it's the small business owner, not one of a team of compliance officers, who is charged with understanding new regulations, filling out required paperwork, and ensuring the business is in full compliance with new and ever-changing federal mandates. The uncertainty caused by future regulation negatively affects a small business owner's ability to plan for future growth. For small business, the problem of overregulation has been further exacerbated by the broad deference federal courts give to executive agencies in their interpretations of statutes passed by Congress. This judicial deference to executive agencies, known as Chevron deference, has led to a breakdown in our constitutional system of checks and balances. Therefore, NFIB welcomed Judge Gorsuch's concurring opinion last year in Gutierrez, encouraging the Supreme Court to revisit the Chevron doctrine. In my written testimony, I referenced 3 cases where the Chevron doctrine has caused serious harm to small business. For example, in City of Arlington versus the FCC, the Supreme Court invoked Chevron to find that courts must defer to an agency's interpretation of its own statutory authority. By extending Chevron deference to agency determinations of its own jurisdiction, the court set a dangerous precedent that encourages agency aggrandizement of regulatory authority with minimal judicial oversight. By abdicating its responsibility to determine the scope of the agency's statutory authority, the court signaled that agencies may intrude into the affairs of states and businesses with impunity, as long as their actions are justified as reasonable to the slightest degree. Our constitutional system of governing and our separation of powers doctrine play a large role in empowering the vitality of small businesses in the United States. When the system erodes or functions less perfectly, there is an adverse impact on small business and our nation's economy. Small businesses, like every American, have an important stake in who fills Justice Antonin Scalia's seat. NFIB is pleased to support the nomination of Judge Neil Gorsuch to the U.S. Supreme Court. Thank you.
Thank you very much. Our next witness is the former Deputy Assistant Attorney General for Civil Rights who has specialized in disability rights. We're delighted to hear her testimony. Ms. Hill.
Thank you very much for inviting me to speak today. I'm an attorney with more than 20 years' experience implementing the laws protecting the rights of people with disabilities. I have serious concerns about Judge Gorsuch's approach to and acceptance of America's disability civil rights laws and the basic principles of disability rights. People with disabilities have long experienced what former President and then candidate George W. Bush called the soft bigotry of low expectations. Unfortunately, Judge Gorsuch bakes these very low expectations into his disability rights jurisprudence, in spite of Congress's bipartisan attempts to dismantle such prejudices through federal disability rights laws. Judge Gorsuch's decisions on the education of our children with disabilities are troubling, not just for their devastating human consequences, but also for their dismissiveness of the law as established by Congress. The Individuals with Disabilities Act, Education Act, or IDEA, requires public schools to ensure a free, appropriate public education for each student with a disability. In the Luke P. case that you heard about earlier, Judge Gorsuch read the IDEA to require only an education that is merely more than de minimis. That concept appears nowhere in the statutory text of the IDEA or in Supreme Court precedent. Judge Gorsuch adopted this standard in spite of Supreme Court precedent requiring educational benefits to be meaningful, in spite of statutory text requiring appropriate educational programs, and in spite of Congress's repeated updates to the IDEA explicitly calling for high educational standards for children with disabilities. Yet in Luke P., George Gorsuch substituted his own opinion for that of 3 decision-makers who had found that Luke's school did not provide an appropriate or meaningful educational benefit. Nor did Tenth Circuit precedent require the merely standard. For a judge that claims fidelity to the principles of judicial conservatism, a decision to overrule the findings of 3 lower courts in a way that ignores statutory text and congressional intent is deeply troubling. Luke's records showed that he was failing in over 75% of the goals in his plan. Few parents in this country would find a 25% success rate to be appropriate or meaningful for their child with or without a disability. Yet Judge Gorsuch found that 25% success was a passing grade for Luke's school. Notably, a little over a year after the change in his placement, as you've heard this morning, Luke made significant progress in the goals that his prior school had failed in. It was Judge Gorsuch's expectations, not Luke's capabilities, that were de minimis in this case. Just yesterday, the Supreme Court explicitly and unanimously rejected Judge Gorsuch's merely more than de minimis standard. The court found Judge Gorsuch's standard mischaracterized the intent and language of both Congress and Supreme Court precedent. The court found in requiring an appropriate public education, Congress meant what it said. The court stated, when all is said and done, a student offered an educational program providing merely more than de minimis progress from year to year can hardly be said to have been offered an education at all. Unfortunately, it is likely too late for many of the children with disabilities in Colorado, Kansas, New Mexico, Oklahoma, Utah, and Wyoming who have been subjected to the soft bigotry of de minimis expectations for nearly 10 years. Judge Gorsuch's other IDEA opinions have shifted standards of review and created legal minefields of administrative processes to undermine the education rights of students with disabilities. And Judge Gorsuch's opinions on the rights of adults with disabilities also reflect, rather than challenge, the stereotypes that Congress enacted in federal disability rights law, rejected in disability rights law. Congress passed the Americans with Disabilities Act, or ADA, to open doors to the workplace for people with disabilities. But Judge Gorsuch, in 2010, held that an employee with multiple sclerosis did not have a disability because she was able to work. He made this holding in spite of both the ADA and the ADA Amendments Act of 2008, where Congress made clear that the ADA provides and has always provided protection to people with MS, and that disability is not defined, catch-22-like, as an inability to work. Federal disability laws are intended to address not just blatant discriminatory treatment of people with disabilities, but the ways the employment processes, benefits, and buildings have been designed in ways that inherently exclude people with disabilities. This is the basis for the central ADA requirement of reasonable accommodation. In the case of Wang versus Kansas State University, a professor requested a slight extension of her leave time to return to work when her Kansas experienced an H1N1 outbreak that could have risked her life. The university routinely allowed one-year sabbaticals for other professors, but Judge Gorsuch insisted that Professor Wang could only extend her leave if she was already entitled to such a sabbatical. The ADA asked not just whether an employee with a disability was offered what she was contractually entitled to, but also whether something more, a reasonable accommodation, is available. Judge Gorsuch ignored that test. Instead, he suggested that Congress was wrong to require leave as an accommodation at all, and that leave of over 6 months was inherently unreasonable, no matter what other employees were given. You may believe that a judge's role is to protect the dignity of all people, and especially those of disempowered minority groups, or you may simply believe that a judge's role is to remain faithful to the clear intent of Congress as expressed in statutes. Either way, Judge Gorsuch's opinions in disability rights issues do not meet that standard.
Thank you, Ms. Hill. Senator Hatch, do you have questions?
Yes, Professor Turley. I'm sorry. Professor Turley?
Yes, sir.
You've observed and written about the confirmation process for a long time. Now, some of my Democratic friends have been saying that the only way to find out what they need to know about Judge Gorsuch is to demand what Justice Ginsburg once called hints, forecasts, and previews about his future vote
cases that will come before the Supreme Court. Now, your testimony is very different. In your written statement, you insist that, quote, we have a very good idea of who Judge Gorsuch is and the type of justice he will be, unquote. Now, do you agree with me that results-oriented litmus tests based on specific issues are not the best standard for evaluating the fitness of a Supreme Court nominee?
Absolutely. And when I referred to knowing what type of judge this man is, I was referring to the fact that he has a well-known jurisprudence. He has a well-known view of the Constitution. He shares that distinction as a nominee with the man he would replace. And that's one of the reasons I believe he will have a lasting legacy. The reason that Justice Scalia has such a lasting legacy is that he's a rarity. He actually changed the court more than it had changed him because he came to the court with a clear understanding of his jurisprudence. Now, when I look at Judge Gorsuch, I see someone that, quite frankly, is going to follow his conscience. He's not going to be very predictable. I don't think he'll be robotic. I think that view, his jurisprudential view, will take him to the left and the right of the spectrum. What we do know is he's a textualist. That should come as no surprise, and I don't think that's a vice. But what his opinions also show is someone with an intense intellectual curiosity and also an intense independence. I could think of no better possible nominee than that. I don't want a blind date. I don't want someone who we know nothing about. What we have in Judge Gorsuch is someone who wasn't just a pedestrian, not participating in these important debates. He got involved, and I respect that. And I don't think we should penalize someone for being active in debating these issues.
That's a good point. The suggestion's been made in this hearing that concern about the Chevron doctrine, which requires deference to executive branch agency interpretations of the law, is just another way of opposing regulation in general. One Democratic senator even said that without Chevron, agencies will not have the authority to address problems at all. Do you agree with that characterization?
No, I don't. I share Judge Gorsuch's view on Chevron. We come from two different places, I think, probably politically. But I think how you view Chevron depends a lot on whether you view it from a constitutional standpoint or from an administrative law standpoint. I think I share Judge Gorsuch's view, or looking at it through the lens of a constitutional standpoint. Chevron is troubling because it does tend to usurp a traditional role of the courts. It also tends to usurp a role of this body. And I also don't think that the suggestion that if Chevron was set aside, that all of Rome would burn. I think that Judge Gorsuch made a very good point when he says, what do people think? And one of his opinions is, what do people think is going to happen if we don't have Chevron? What's going to happen is we'll be in the same position we were before Chevron, which wasn't a bad position. You had the Skidmore case, where Justice Jackson, someone that Judge Gorsuch really respects a great deal, said, look, we have to respect agency opinions. We have to give them great weight. The APA itself, I believe in Section 706, says that you have to defer to that. So there's not a cliff here that people are talking about. What it does by moving away from Chevron, I think, is to get the courts more heavily involved in the review of agency decision-making, and also to give more authority back to this body where I believe it should rest.
Great. I agree with you. Ms. Harmon, we often speak about the impact of court decisions on the parties in to a specific case and beyond. Now, I really appreciate I really appreciated your response in this area and your comments. Because I think they provide an important perspective on this issue. And I'm sure you know from observing this process, my Democratic colleagues focus only on which party wins or loses or which narrow political interest is advanced by the decision in an individual case. Now, you seem to have a very different take. Your testimony emphasizes more broadly that clarity about the law and adherence to basic principles such as separation of powers have the most important impact. Now, that's why you have such a high praise for Judge Gorsuch's approach, not only to making decisions, but on writing the opinions that explain those decisions as well. Now, my view is that the law, not the judge, should determine the outcome of individual cases and the broader impact of those decisions. Do you agree with that? Well, that was a nice, quick answer.
By saying, that there was a good discussion. Oh, sorry. A good discussion with Senator Tillis about this as well, which is the separation of powers is important because coming here before you is where my members, small business owners, are going to have the greatest impact. You are in the light of day with a true public discourse about what the law should be. They're not going to be in every courtroom in the country. They're not going to be in every agency walking the halls. And they need to know that once you all enact a law, the regulation is issued that is appropriately within that statutory framework. It's a law they can rely on because that certainty is the only way for them to be able to do business. Certainty is a critical component of small business owners' abilities to operate their business.
Thank you.
Thank you.
Senator Whitehouse.
Thank you, Chairman. May I ask unanimous consent? We have Ms. McKee here from Demos. May I ask unanimous consent that Demos's 2017 report titled Election Money Resulting Directly from Supreme Court Rulings, as well as a March 13, 2000 letter from 109 House members to Chairman Grassley and Ranking Member Feinstein, urging this committee to question Judge Gorsuch about money in politics, and a 2017 Demos report titled Money in Politics, Racial Equity, and the U.S. Supreme Court, and fourth and finally a 2015 Demos report titled Breaking the Vicious Cycle, Rescuing Our Democracy and Our Economy by Transforming the Supreme Court's Flawed Approach to Money in Politics, all be entered into the record.
Without objection.
Thank you very much. Ms. McGee, welcome. I appreciate that you are here and the work that Demos has done to shed some light on the problem of money in politics and the influence that it gives special interest groups. We have kind of an unusual circumstance here in that President Trump originally outsourced the creation of the list from which Judge Gorsuch was selected to a pair of well-known right-wing interest groups. And then the notification to Judge Gorsuch that he describes in his description of the selection process, the opening sentence is on or about December 2nd, 2016, I was contacted by Leonard Leo, who is the head of one of those same special interest groups. Then it's been reported in the news that the White House outsourced the political campaign on behalf of Judge Gorsuch to those interest groups. And indeed, we have seen reports of a $10 million political campaign to try to influence the Senate in Judge Gorsuch's favor through a front group. So we don't know who the real donors are. It's dark money that is behind that entire operation. And it was the same front group that spent a nearly equivalent amount of money trying to disrupt the nomination of Judge Merrick Garland. And finally, we have the Colorado reporting on Judge Gorsuch's friend and appears his patron in the quest for the 10th Circuit seat, Mr. Philip Anschutz, who is a billionaire who is also a very big political spender. And all of that, I think, causes concern to some of us that although the talk may be about Olympian detachment, the actual operation of getting Judge Gorsuch before us has been special interest, dark money politics. And I'd like to ask you to react to that.
Thank you, Senator Whitehouse. I think you're right to express concern about this, the same way that the American people, including 91% of President Trump's own voters, have expressed concern about the role of the Supreme Court in expanding our current big money system. Judge Gorsuch had the opportunity over the past couple of days to distance himself from the entire problem of Citizens United, either spoken of expansively in terms of the influence of the wealthy millionaires and billionaires and special interests in our politics, to even some of the more narrow concerns. I was particularly concerned in your exchange, Senator Whitehouse, with the judge when you gave him an opportunity to talk about something that is his predecessor, his potential predecessors, one of his great North Stars, which is the importance of disclosure in our campaign finance system. And instead of saying clearly that there is a public interest in knowing who is spending millions of dollars to buy influence with our politicians, he was quite evasive. And in fact, to my dismay, raised the idea that disclosure chills speech, and even suggested that the $650 million in secret money from society's most powerful, which is what we've seen since Citizens United, would be on the same level as the brave civil rights leaders in the NAACP case, people who endured violence, bombings, and shootings for their political activism. And if you don't mind, I just want to read just one sentence from what Senator Scalia said in Justice Scalia said in Doe v. Reed about the importance of disclosure, which gives us a sense that he might even be parting with Scalia on this important piece. There are laws against threats and intimidation and harsh criticism, short of unlawful action, is a price our people have traditionally been willing to pay for self-governance. Requiring people to stand up in public for their political acts fosters civic courage, without which democracy is doomed.
My time has expired, Chairman. Thank you very much. Thank you, Ms. McGee.
Thank you, Senator.
Thank you. Thanks to Senator Whitehouse and you for filling in when I had to go vote. Professor Solom, while many try to argue that originalism is inherently conservative, others have pointed out that originalism has been ascribed to by liberal judges and academics as well. Professor Cass Sunstein had at Harvard Law School, for example, once described the late Justice Hugo Black as a liberal originalist. Would you agree that originalism is not by itself ideologically or political in nature?
Yes, I would, Chairman Grassley. And if I might just give an example or two, it's absolutely true that much of the interest in originalism at the beginning was generated by critics of Warren Court decisions, and originalism has been associated with conservatives to some extent. But originalism is the idea that we're going to enforce the original meaning of the United States Constitution. And the United States Constitution has implications that both conservatives and progressives, both Democrats and Republicans, can welcome. Let me give an example that relates to the question we've just been discussing, the rights of corporations. Justice Thomas, in his opinion, in the McDonald case, says that incorporation of the Bill of Rights can only be justified under the Privileges or Immunities Clause of the United States Constitution. The Privileges or Immunities Clause is different than the Equal Protection Clause or the Due Process Clause. Those clauses guarantee rights to all persons. The Privileges or Immunities Clause guarantees rights only to citizens, and corporations are not citizens. Now, this is not a result that corporations will welcome at the state level, where the 14th Amendment applies, but it is an implication of the original public meaning of the Constitution.
Okay. Thank you. Mr. Lampkin, you worked with the judge when he was in private practice at Kellogg-Huber, and you said you support his nomination to the Supreme Court. Do you think his experience as a trial lawyer would be relevant to his work on the Supreme Court?
Yes, I think it's highly relevant. As somebody who was a trial lawyer for many years, the judge has, from what I see, great respect for the record, great respect for the factual development, whether that record is one that's developed by this body in support of the statutes that it enacts, or it's a record created by the parties at trial. And I think when you are a trial lawyer and you're involved in those, you've developed that type of great respect that's critically important to really understanding what's going on in the cases, to understanding not merely what the abstract principles of law are, but how they're affecting people, and then how the process plays out in the trial courts. I think practical experience as a trial lawyer is something that is not as common among our Supreme Court justices now as it should be, and I think that's a good perspective he would bring to bear.
Okay. Ms. Harned, my last question. We've heard a lot during these hearings about the rule of law. We've heard in particular about how it's the role of judges to enforce laws as they've been written by the Congress. Can you explain why it's important to your clientele, small business men and women, for judges to interpret statutes according to the text?
Right, because small business owners need to know what the rules of the road are, what is expected of them, and not have to worry that because of one judge's decision, a practice that they had been doing that they thought was perfectly legal one day is now illegal, and so that is why small business owners are so committed to the way that the separation of powers works, where legislators legislate and judges tell us what the law is, and that is why we have so much respect for Judge Gorsuch's work.
Okay. Thank you. I yield back my time.
Senator Coons.
Thank you, Senator Flake. Ms. Hill, if I might, earlier today we heard compelling testimony from Jeff Perkins about his son Luke and about the consequences for Luke and his family of Judge Gorsuch's perspective in his opinion in the 10th Circuit. And then pointedly, the Supreme Court disagreed with Judge Gorsuch's reasoning. I believe the goal of laws passed by Congress like the ADA and the IDEA is access, opportunity, and participation, not isolation and segregation. I'd be interested, Ms. Mill, both Judge Gorsuch yesterday and Judge Taha today insisted that Judge Gorsuch was bound by precedent, both Circuit and Supreme Court, to set the standard under the IDA as merely more than de minimis. Are they right?
I don't believe so. Of course, the Supreme Court yesterday indicated that it was not correct to approach Rowley or interpret Rowley as meaning that the standard was merely more than de minimis. Rather, the standard was for meaningful and appropriate education, just as Congress had said that it was. In addition, I looked more closely at the Urban case. That was the case that Judge Gorsuch cited for the de minimis standard, which, by the way, still did not use the word merely. In Urban, there was no dispute about whether sufficient services had been provided for this child. There was a dispute about whether a procedural requirement of the IDEA had been followed, and whether that failure to follow the procedural requirement had created a substantive violation. To the extent that there was no argument over whether the free appropriate public education had been provided, any argument about what the standard for free appropriate public accommodation was is largely dicta.
Thank you, Ms. Hill. Mr. Gallagher, if I might, in a 2013 case, I think it's New Mexico off-highway vehicle versus U.S. Forest Service, the Sierra Club attempted to intervene in a case attacking this Forest Service rule, and the court allowed you to participate. Judge Gorsuch dissented and wouldn't have allowed Sierra Club participation in the case, even though none of the litigants opposed your participation. In another case in 2011, Judge Gorsuch voted to block another environmental group from litigating to assert its interest. Why do you think it's important that interest groups like the Sierra Club be allowed to participate, and how do you think Judge Gorsuch's position would affect advocates' ability to be engaged on litigation around the environment?
Thank you, Senator. Right now, when President Trump and his advisor Steve Bannon are threatening to dismantle the EPA, and when we have a new administrator of the EPA, Scott Pruitt, who essentially eviscerated environmental enforcement while the Attorney General of Oklahoma, it's critical that citizens be able to enforce environmental laws. This body legislated citizens' rights to enforce environmental laws. There are citizen suit provisions in all of the major environmental laws. If we can't get access to court, and Mr. Trump and Mr. Pruitt are not going to protect our drinking water, who are we going to call?
Thank you, Mr. Gallagher. Ms. Graves, in Strickland versus UPS, Judge Gorsuch's 10th Circuit colleagues found that a woman had shown enough evidence of discrimination based on sex, to have a jury rule on her case. The woman had multiple coworkers testify she was treated worse than her male coworkers. Though the law required the court to look at the evidence in the light most favorable to the woman, Judge Gorsuch, again, dissented. Can you tell us more about this case and what it says about Judge Gorsuch's approach to deciding these opinions?
Sure. Thank you, Senator Coons. I think that the Strickland case is a good example here of the concern that we have when Judge Gorsuch says he just applies law to facts. Because here the real issue was that there were a lot of facts, and these facts were disputed, in fact. And when facts are disputed, the thing to do is have the jury decide, have the jury determine and resolve the facts. Here, despite a lot of evidence that she should have been able to continue her claim, Judge Gorsuch said, no, that's not enough. And so in that case, that's an example of, yes, he was applying the law to the facts, but the jury itself is the one who's supposed to resolve the facts.
Thank you, Ms. Graves. Thank you, Mr. Chairman.
Thank you. Senator Kennedy.
Thank you, Mr. Chairman. Ms. McGee. Is it McGee or McGee?
McGee. That's
McGee.
Thank you.
Tell me, I listened to your testimony about your criticism of Judge Gorsuch and Citizens United. Tell me what your complaint is with respect to Judge Gorsuch and Citizens United, just briefly.
Sure, absolutely. First of all, we believe that based on his record in two cases, Hobby Lobby and Riddle v. Hickenlooper, that you have a recipe for striking down some of our last remaining protections against big money. He went out of his way in Hickenlooper.
I don't mean to interrupt you, but I only got 5 minutes.
Okay.
I understand now. Do you really expect a nominee for the United States Supreme Court, whether he or she is nominated by a Democratic president or a Republican president, to come before the United States Judiciary Committee and talk about what's good policy or bad policy?
Fortunately, he doesn't have to get into policy to just talk about enduring democratic principles. And I also think that the Heritage Foundation, the number of right-wing organizations that are anti-campaign finance reform that have backed his nomination for the court would be surprised to learn that he was at all ambiguous about Citizens United, which is one of the most important court cases in recent memory, and where all of the principles around grandly interpreting the First Amendment to give and protect the rights of millionaires and billionaires to spend unlimited amounts was just a continuation of a set of ideological jurisprudence that I would be surprised to hear him part from, and he didn't when he had the opportunity.
I understand how you feel about Citizens United, but I want to understand your criticism of Judge Gorsuch as a nominee for the United States Supreme Court. You're criticizing Judge Gorsuch for not coming before this body and offering a policy preference in terms of campaign finance in elections in America?
I'm not criticizing the judge. I am saying that he had an opportunity to say basic principles about our democracy and upholding an interpretation of the First Amendment that would protect a vision of one person, one vote. He was asked multiple times about many different issues concerning campaign finance reform, including cases where he went out of his way to write concurrences on majority opinions that put into doubt his opinions in future cases about issues such as the scrutiny level for campaign contributions, which is, to date, we believe a matter of settled law, and the very possibility of moving into corporations giving direct contributions to candidates based on his concurrence in Hobby Lobby.
And you would prefer to have a nominee who agrees with you on those policy issues?
I would prefer to have a nominee who was open to considering the facts. And we have seen that since Citizens United, the facts have shown that some of the basic premises, the idea that independent spending is actually independent and can't corrupt, the idea that disclosure is real, have been proven false.
All right. I'm going to put you down as doubtful on Citizens United. Okay.
Thank you, Senator.
Ms. Hill, how do you think judges ought to decide cases? Could you turn your mic on for me?
I keep doing it. I think judges should decide the cases based on the law as expressed by Congress, interpreted by the agencies, and applied to the facts in front of them.
What if the agencies got it wrong?
If the agencies got it wrong, there are administrative procedures processes through which to go through to challenge those incorrections.
Okay. Do you think that a party's wealth or status or power should have any effect whatsoever on the outcome of a case?
No, I do not.
Okay. Thank you, Mr. Chairman. I yield back my time.
Thank you. Before going to the next panel, let me just ask a couple of questions. Mrs. Harned, tell me, your organization promotes small business, obviously, and regulation has a little to do with the success or failure of small business. What have you seen over the years with regard to decisions by the Supreme Court or other courts that has impacted the ability of small business to succeed?
Right. Well, that has been really over the last several decades. We continue to see an increasing regulatory state, and in large part, that is because of agency deference that courts are giving to agencies, the Chevron doctrine. And we have seen this firsthand with the number of cases in which we've gotten involved. I have several referenced in my testimony where, because of that agency deference, small business owners, the interpretation of the regulation by the agency governs, and as a result, a small business owner is sued and out millions of dollars in one case, the Knack versus Wahlberg case that I talk about here. But more importantly and more broadly on the regulatory state, generally, small business owners do bear the disproportionate burden of regulation on their business as compared to the larger counterparts. It's been a primary concern, the reason they have not been able to grow over the past 9 years. And so we are, that is why we are so committed and so encouraged to see that Judge Gorsuch recognizes, as he said in his testimony, raised his hand to the Supreme Court and said, look, Chevron deference, this may be a time where we need to revisit that because we do think it is responsible for increasing the regulatory state in this country.
Right. Thank you. Mr. Turley, I'd like your thoughts kind of on that similar theme. With Chevron deference, certainly Judge Gorsuch has expressed some skepticism about it, to put it mildly, I hope. But with regard to technology, which is an increasing percentage or share of our economy, what we've seen over the past several years is you have one administration whose agencies will regulate in a certain way. The new administration comes in with maybe a completely different idea. We just dealt with a Congressional Review Act on certain tech regulations, internet regulations, just a few minutes ago on the floor. And then the next administration might come in with something completely different. One thing that small business and large business, any business, cannot stand is uncertainty moving ahead. Is with Chevron deference, looking back for the Congress to have maybe a more balanced or more predictable application of statutes which will govern regulation, is that a better way? What do you say?
I do think it's a better way to move beyond Chevron. I've been a critic of Chevron for many years. I'm a particular critic of Brand X, which is the subject of one of these opinions. I thought the judge was right on that one. He raised this issue. A lot of people don't realize that Brand X says that an agency can essentially negate the legal interpretation of a federal court. And he appropriately said, I thought that courts interpret the law after Marbury versus Madison. But that's how Chevron works. It's sort of the Marbury of the administrative state, saying that they can be the final word. And I think what you're seeing in our system is a dangerous shift of the center of gravity. This is a system, a tripartite system, that was designed to have three branches held together sort of by inverse pressure in a fixed orbit that Madison set. And we have this rising fourth branch of administrative agencies. I happen to identify with many people in those bureaucracies because they're dweebs like me. You know, they have advanced degrees, they're sort of wonky. But the fact is that we have a fourth branch that I think is a dangerous change in our system, one that we're not having a debate over. And Chevron has fueled that change. If we didn't have Chevron, we would largely go back to the conditions of cases like Skidmore, where the courts gave a lot of deference, even without Chevron. You have the APA, which requires deference to agencies. But what it would do is allow judges to rule on what the law means. I also know, by the way, that apropos of your question, Chevron was actually a case that was a victory for Judge Gorsuch's mother, and this was actually a victory of Republicans that were trying to reverse measures that were put into place by a previous Democratic administration and used administrative authority to do that. So I would caution those that have suggested that this is going to be an apocalyptic moment. What it would do if we went beyond Chevron is return us to a position closer to the design of our government.
Well, thank you. My time is up, and I believe time for the panel. We'll go on to the next panel. Thank you for your service. And we'll call the next panel. If they want to set the nameplates, it will consist of Ms. Clark, Ms. Kirsenau, Ms. Warbelow, Ms. Fisher, Ms. Miller, Ms. Smith, Professor Marshall, Professor Mayer, Ms. Phillips, and Professor Jaffer. Oh, wait, Miller here. Yeah. That's okay.
Pretty interesting. Excellent. It's pretty interesting. We should plagiarize that. Let's do it.
If you'll please stand and raise your right arm. Do you swear that the testimony that you are about to give before the committee will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. Please be seated. Kristen Clark is the President and CEO of the Lawyers Committee for Civil Rights Under Law. Peter Kirsenau is a partner with the firm Benich Labor Employment Practice Group and is serving his third term on the U.S. Commission for Human Rights, or for Civil Rights, I'm sorry. Sarah Warbelow is the legal director for the Human Rights Campaign. Alice Fisher is a partner in Latham and Watkins, Washington, D.C. office, and is a member of the firm's executive committee. From 2005 to 2008, she served as Assistant Attorney General in charge of the Criminal Division at the Department of Justice. Amy Miller is the President and CEO and founder of Whole Women's Health. Sarah Smith is a senior counsel at Beckett. She clerked for then Judge Alito on the Third Circuit Court of Appeals for Justice Clarence Thomas and then for Justice Alito on the Supreme Court. Professor William Marshall is the William Rand Keenan Jr. Distinguished Professor of Law at the University of North Carolina. Tim Meyer is the former law clerk for Judge Gorsuch from 2007 to 2008. He's now Professor of Law and Enterprise Scholar at Vanderbilt Law School. Sandy Phillips is the mother of Jessica Gownie, who was, thank you, Gowie, got it. Thank you, who was tragically killed in the 2012 shooting at the Aurora, Colorado movie theater. Jamil Jafar is a former law clerk for Judge Gorsuch from 2006 to 2007. He currently serves as adjunct professor, National Security Institute founder, and director of the Homeland Security Law Program at the Antonin Scalia Law School at George Mason University. I welcome you all to the committee. Look forward to hearing your testimony. This will be 5 minutes each, if you can summarize that way. We'll proceed after that with 5-minute rounds. But let's go ahead, Ms. Clark.
I want to thank the distinguished members of this committee for the opportunity to testify today on behalf of the Lawyers Committee for Civil Rights Under Law. We are one of the nation's historic, nonpartisan civil rights organizations with the unique mission of mobilizing lawyers across the country to provide critical pro bono support to advance our work. The Supreme Court occupies a central place in American democracy, and for African Americans and other minorities, the court has been a crucial forum for seeking equal justice under law. Historically, minority groups have looked to the court to vindicate their constitutional and civil rights. We have reviewed the civil rights record of Judge Neil Gorsuch, as we have done for all Supreme Court nominees for the last several decades. We do not believe that the record is sufficient to conclude that he meets our standard, which requires demonstration of a profound respect for the importance of protecting civil rights afforded by the Constitution and the nation's civil rights laws. Judge Gorsuch's views reflect a very narrow definition of what constitutes a civil right, and he has deep skepticism about the importance of protecting those rights in the courtroom. Our concerns are especially pronounced with respect to the question of whether he will fairly interpret and apply one of our nation's most important civil rights laws, the Voting Rights Act. In 2013, the Supreme Court issued a decision that gutted the act in Shelby County, Alabama v. Holder. At issue in Shelby County were the Section 5 preclearance provision of the act that helped identify and successfully block hundreds of unconstitutional and discriminatory voting changes, and the Section 4 provision that determined where the law applied. A closely divided court ruled that Section 4 was unconstitutional, a decision which eviscerated the heart of the Voting Rights Act. Witnesses have drawn parallels between Judge Gorsuch and the late Justice Scalia. During oral argument in Shelby County, Justice Scalia referred to Congress's renewal of the Voting Rights Act as the, quote, perpetuation of racial entitlement. That was a startling perspective on a law that has ensured that millions of American citizens have not, merely because of the color of their skin, been unlawfully deprived of the most sacred right in our democracy. What is most troubling about the court's decision in Shelby County is that the carefully considered judgment of Congress was set aside. In 2006, the Senate voted to renew Section 5 by a vote of 98-0 after documenting overwhelming evidence of ongoing discrimination against minority voters. It is unclear whether Judge Gorsuch appreciates Congress's broad enforcement powers under the 14th and 15th Amendments, and unclear whether he brings awareness of the widespread voting discrimination and voter suppression that we continue to face today. The right to vote is too important. We must understand whether Judge Gorsuch is committed to fairly interpreting and preserving what remains of the Voting Rights Act. Equally important are questions concerning Judge Gorsuch's tenure at the U.S. Department of Justice between 2005 and 2006, when he occupied the role of Principal Deputy Associate Attorney General. As a career attorney at the Civil Rights Division of the Justice Department during that time, I am personally aware of issues that led to the politicization of the agency's civil rights work. Those views were substantiated in a July 2008 Inspector General's report, which found that politicization of the Civil Rights Division's hiring practices and its work violated federal law and Justice Department policy. We must not turn a blind eye to the fact that Judge Gorsuch had some responsibility for overseeing the division during this time. The materials provided by Judge Gorsuch, together with his Senate questionnaire, do not clarify or elucidate the extent of his involvement in the significant problems that tarnished the work and integrity of the Civil Rights Division at this time. I urge the Senate to seek answers to these important questions. Before I conclude, I want to say a brief word about Judge Gorsuch's record on criminal justice issues. Criminal justice concerns remain at the forefront for many African American, Latino, and minority communities. Our review shows that he takes an unusually narrow view of the constitutional rights of defendants, particularly under the Fourth Amendment. Judge Gorsuch has also shown extreme deference to police officers in excessive force decisions. In closing, I must observe that this nomination arises at a tumultuous moment in our nation's history. We have seen intensifying efforts to restrict the rights of minority voters, unconstitutional policing practices, rising xenophobia, religious intolerance, and other circumstances that make clear the fragile state of our democracy. Our nation deserves a Supreme Court justice who will interpret the Constitution and civil rights laws in a way that recognizes that discrimination is both ongoing and a threat to democracy, and who is committed to ensuring equal justice under law for all Americans. Based on the record to date, I am not able to support the nomination of Judge Gorsuch to the Supreme Court today. I respectfully request that the Lawyers Committee for Civil Rights Under Law's report on the nomination of Judge Gorsuch and accompanying letter signed by more than 100 of our board members expressing concern regarding the nomination be entered into the record.
Without objection.
Thank you.
Thank you, Ms. Clark. Mr. Kirsanow.
Thank you, Mr. Chairman, members of the committee. I'm Peter Kirsanow, member of the U.S. Commission on Civil Rights and a partner of the Labor Employment Practice Group of Benish Friedlander. I speak as one member of the Commission on Civil Rights, not necessarily on behalf of the Commission as a whole. The U.S. Commission on Civil Rights was established pursuant to the 1957 Civil Rights Act to, among other things, act as a national clearinghouse for information related to discrimination and denials of equal protection, and in furtherance of that clearinghouse function, and with the help of my assistant, I've reviewed the nearly 200 cases related to civil rights that Judge Gorsuch had authored or participated in at the 10th Circuit. These opinions relate to, among other things, Title VII, ADA, ADEA, IDEA, Equal Protection Clause, and a host of other provisions related to civil rights. And our examination reveals that Judge Gorsuch's approach to civil rights cases is consistent with generally accepted textual interpretation of the relevant statutory and constitutional provisions, as well as governing precedent. His opinions are squarely within the judicial mainstream when it comes to civil rights. Of the opinions we examined related to civil rights that Judge Gorsuch participated in, he was in the minority in only 5% of those cases. In 43 cases, he was on a 3-judge panel in which the 2 other panel members were appointed by presidents of the Democratic Party, and in 94% of those cases, he joined the majority opinion or concurred in the result. A useful example of Judge Gorsuch's mainstream textualism, mindful of the limits of the judiciary and the prerogatives of the legislature is his dissent in Trans Am Trucking versus Administrative Review Board, where a majority of the panel found that a statutory provision that provided that an employer may not discharge an employee who refuses to operate a vehicle where that employee has a reasonable apprehension of serious bodily harm actually meant that the employee may not be discharged if he operates the vehicle contrary to employer instructions. Judge Gorsuch applied the plain text of the statute in a very precise manner and noted that the employee in question had done the opposite of the statutory privilege. That is, he had operated the vehicle, not refused to operate the vehicle. Similarly, Judge Gorsuch's reasoned deference to precedent and his interpretation of the text of the governing statutes yields cases and a record on civil rights that's consistent with prevailing civil rights norms. For example, Carrera versus Tyson Foods. Judge Gorsuch upheld summary judgment against a plaintiff in a hostile environment sexual harassment case where there was no evidence that there was a hostile environment. The evidence proffered was that supervisors were standoffish. That standing alone does not constitute a hostile environment. Moreover, the defendant had immediately discharged the employees who had made provocative gestures and immediately transferred plaintiff upon her request. Similarly, in Gaff versus St. Mary's Regional Medical Center, Judge Gorsuch upheld summary judgment in a retaliation claim where there was no evidence that the hospital had fired the plaintiff for reporting sexually explicit remarks made by a coworker, as opposed to firing plaintiff because the plaintiff had threatened to shoot such coworker. As pertains to religious discrimination cases, Judge Gorsuch's record shows that he takes First Amendment issues soberly and seriously, regardless of whether or not the issue at hand may be trivial to some, may be obscure, or the plaintiff is unsympathetic, or the plaintiff's beliefs may be at odds with prevailing societal norms. An example is Yellow Bear versus Lampert, in which Judge Gorsuch upheld the free exercise rights of an unsympathetic plaintiff who had murdered a little girl, which plaintiff had been denied his right to access a sweat lodge pursuant to his religious beliefs. Judge Gorsuch has also noted that RFRA protections might be available to individuals and families who are given the Hobson's choice of either abiding by their sincerely held religious beliefs or saving their business. In sum, Judge Gorsuch's approach to civil rights cases is consistent with the norms in this jurisprudence. His record shows that he's a careful and exacting judge who has great respect for the constitutional order, the rule of law, the role of Congress, and the corresponding limits on judicial authority. He is consistent with mainstream textual interpretation of the governing statutes, and in addition to that, all of his record shows that he will faithfully and carefully apply the law to protect the civil rights of all Americans. Thank you, Mr. Chairman.
Thank you, Mr. Kirsten. Now, if you're wondering where my colleagues are, there's a vote going on right now. Chairman Grassley will be back in a minute, and I'll go and vote. But I assume some other members will come in as well. Ms. Warbelow.
Thank you. On behalf of the Human Rights Campaign, the nation's largest civil rights advocacy organization for lesbian, gay, bisexual, transgender, and queer people, I'm honored to be here before you today, representing our nearly 2 million members and supporters nationwide. Unfortunately, I'm disappointed that the topic for discussion is President Trump's nominee to the Supreme Court, Mr. Neil Gorsuch. LGBTQ people are no strangers to the Supreme Court. We understand the power of the court to affirm or deny our most basic rights. Jim Obergefell and his partner John Arthur had to be medevaced to a tarmac in Maryland in order to marry before John died from ALS because their home state of Ohio refused to allow them a marriage license. Their heartbreak didn't end on that Maryland tarmac. The state of Ohio attempted to erase their marriage by refusing to place Jim's name as a surviving spouse on John's death certificate. By a narrow 5-4 ruling, the Supreme Court validated Jim and John's relationship and extended marriage equality nationwide. By his own words, Judge Gorsuch admitted he would have forced same-sex couples to pay the price of inequality for decades to come. This is why Judge Gorsuch cannot be given a lifetime appointment to the Supreme Court. Time and time again, Judge Gorsuch has employed a dangerous brand of originalism that ignores the essential context and values of each case and the lives that they touch. His record and statements place him squarely in the mold of Justice Antonin Scalia, who consistently demeaned and denied the dignity of LGBTQ people from the bench. Judge Gorsuch has directly questioned the court's recognition of the fundamental right to personal autonomy that has served as a keystone for multiple LGBTQ rights cases. Distressingly, Judge Gorsuch accepted a quote from Justice Scalia in its entirety, equating marriage equality to bestiality, and made no effort to distinguish marriage, one of our society's most sacred traditions, from criminal antisocial behavior. Despite records that Judge Gorsuch is personal friends with LGBTQ people, his choice to embrace this line of reasoning reveals a level of indifference to the LGBTQ community that should be disqualifying for an individual to be appointed to the United States Supreme Court. During his time on the bench, Judge Gorsuch ruled against Rebecca Castle, a transgender woman working for a community college. After being rehired for a second term, Rebecca transitioned and began to use the women's restroom. Halfway through the semester, the school informed her she would have to begin using the men's restroom based on safety concerns. Rebecca was terminated because she refused to subject herself to the dangers of using a men's restroom. As Justice Kennedy made clear in Romer v. Evans, false justifications may never be used to cloak bare animus. That's what happened in Rebecca's case. The Supreme Court justices must be able to discern legitimate government interests from clear hostility to vulnerable communities. Judge Gorsuch's other rulings, such as Hobby Lobby, while not directly addressing the LGBTQ community, have been used to blatantly defend discrimination against LGBTQ people. Amy Stevens is one of these people. After working for a for-profit funeral home for nearly 6 years, she informed the owner she would be transitioning when she returned to work and would be dressing consistent with the women's dress code. Ignoring the employee's strong record, the funeral home owner stripped her of her job based on his belief that it's unacceptable to be transgender. In providing the funeral home a pass from complying with Title VII, the judge in this case adopted Justice Gorsuch's views regarding moral culpability, which callously disregards harm to real people. If this reasoning is widely adopted, it will undermine our core civil rights laws, allowing pervasive discrimination not only against the LGBTQ community, but Americans widely. Areas of law that the majority of Americans view as settled, including marriage equality, are being litigated and debated by groups who are emboldened that a justice like Gorsuch will reopen settled law. The Supreme Court will be asked to hear cases such as those that could decide whether a public school counselor from Mississippi can turn away LGBTQ youth in need, whether City of Houston employees may be stripped of their spousal benefits, or whether moms like Marissa and Tara Pavan must both be listed on their daughter's birth certificate. We might not agree with every decision a Supreme Court justice may make, but we must believe that their commitment to reaching impartial judgments based on fact, not political ideology or bias. And they must agree that LGBTQ people have a fundamental rights protected by the Constitution, and that we, as individuals and a community, are entitled to equal treatment under the law. We need a justice who recognizes our basic equality and shared humanity. Judge Gorsuch has never met this bar, and that is why the Human Rights Campaign opposes his nomination to the Supreme Court.
Thank you, Ms. Warbelow. Ms. Fisher, and I'll have to excuse myself to vote, but Ms. Hirono is here. Thank you.
Thank you, Senator Flake. Thank you. Thank you, Senator Hirono. It's an honor to be here today. It's a privilege to be able to testify in support of my friend and former colleague, Judge Neil Gorsuch. It has been a privilege over the years to watch his career unfold. I had the pleasure of meeting him in 1991 when we both had our summer jobs in law school. He was in his third year of law school. I was getting out of my second year in law school, and we worked together as summer associates that summer in 1991. It may make me the longest person that knew him today that's testifying. Of course, I was struck by his brilliance and his keen intellect, but what was more striking was his character and his integrity and his courtesy and his kindness. Every day he would walk into work and he would stop and he would talk to people, everyone in the office, ask them how they were doing, ask them about their lives, about their troubles, and he would spend so much generosity with his time and his consideration for others. It was almost like it was an unlimited reserve of courtesy, kindness, and good humor to boot. I was the beneficiary of this, and I am forever grateful of the time that he took with me early on in my legal career to spend time counseling me, mentoring me, helping me. It was almost if he cared as much about my success as he did about his own, and I was not alone in the way he treated people. I will be forever thankful for his support, and that's just the man that he is. He's been through the years, as you can see, driven by his devotion to his country and his devotion to public service. And he comports himself with deep humility when he comes into public service. And I can remember our conversations about when he was entering public service and how much that meant to him to have the ability to do that. He has a keen intellect, of course, but he holds himself to the highest standard of excellence and his unwavering commitment to the law, and you've heard him talk about that and many others. Of course, he is an adoring husband to Louise and a devoted father and a devoted friend to many. As I have watched Judge Gorsuch, for many years, I find him a man of the highest personal integrity. He has a commitment to fairness and decency that will serve the Supreme Court well, and I am hopeful that he is confirmed. Thank you.
Thank you. Next we have Amy Miller. Ms. Miller.
Thank you. Chairman Grassley, Senator Feinstein, and members of the committee, I'm very honored to speak with you today. My name is Amy Hagstrom Miller. I am the founder and CEO of Whole Woman's Health, a group of women's health clinics that provide comprehensive reproductive services, including abortion care. I am here today on behalf of abortion providers, women's health advocates, and the people we serve all across the country who deserve access to quality health care delivered with dignity and respect. We are gravely concerned about the nomination of Judge Gorsuch to the U.S. Supreme Court. In fact, Whole Woman's Health joined 54 other reproductive health, rights, and justice organizations in a letter to the Senate opposing Judge Gorsuch's nomination. In our clinics, we offer holistic care for women that includes caring for their heart, their mind, and their body. We envision a world where every woman who has decided to end a pregnancy will be respected and where she will have the information she needs and the quality care she deserves. We were the lead plaintiff in last year's landmark Supreme Court case, Whole Woman's Health v. Hellerstedt, and witnessed how decisions made at the High Court directly impact the lives of women. I know what happens when politicians find devious ways to deny women's constitutional rights, and why it is so important to have independent jurists who respect precedent and the rule of law. Roe v. Wade, the 1973 decision that guaranteed the right to abortion and the right to privacy, has been settled law for more than 4 decades and is being reaffirmed repeatedly by the Supreme Court. Nevertheless, that hasn't stopped legislators across the country from putting roadblocks in front of women seeking abortion care. More than 330 have been passed since 2010. Nowhere was the impact of these laws more evident than in the state of Texas, where anti-abortion legislators passed a law in 2013 that forced over half of the state's clinics to shut down. The law forced women to drive hundreds of miles, even across state lines, to access their right to safe and legal abortion. In some cases, the hurdles were so high, women simply took matters into their own hands. I will never forget the woman who called from South Texas right after the law went into effect. We told her our clinic was shuttered, and she now had to drive 250 miles each way to San Antonio. She told us there was no way she could take 2 days off work, find childcare and the money to drive that far. She said, and I quote, "I will tell you what is in my medicine cabinet, and can you please tell me what to use to do my own abortion?" In our country, where abortion has been legal for more than 40 years, no woman should be forced to take matters into her own hands, nor should she fear criminalization or jail time if she does. We need justices on the bench who oppose unnecessary obstacles to our constitutional rights. Neil Gorsuch is not that judge. I also remember the woman who called from West Texas, where every single clinic had been shut down. She was a single working mother with 3 children. We helped her to find a clinic, raise money for her abortion, childcare, transportation, and lost wages. By the time she made it to a Dallas clinic 8 weeks later, it was too late for her to have an abortion in the state of Texas. We need judges on the court who support our constitutional rights no matter our zip codes. Neil Gorsuch is not that judge. Last year, we took Texas to the Supreme Court, and in its ruling, the court called out these and other clinic shutdown laws for what they are: sham laws that create obstacles to care with no medical basis behind them. Women need to know that if their rights are once again on trial, they will be decided by justices who are independent and not beholden to an ideological agenda. Judge Gorsuch has refused to answer basic questions about his stance on Roe, whole woman's health, or the right to privacy. Yet we know in the Utah Planned Parenthood case, he sided with politicians using misinformation and false claims to defund women's health services. And in the Hobby Lobby contraception case, he supported the notion that corporations are people. Judge Gorsuch's positions raise concerns about his ability to be open-minded, fair, and guided by the Constitution, and not his own ideology or personal beliefs. Your decision on this nomination will have profound impact on all your constituents. Everyone loves someone who has had an abortion, and we all want the people we love and treated to be safe and treated with respect, compassion, and dignity. I urge you to keep this in mind as you consider the awesome responsibility of entrusting a lifetime appointment to the United States Supreme Court. Thank you very much.
Thank you. And Senator Hirono, thank you for filling in so we keep it going. Thank you very much. Now, Ms. Smith.
Thank you, Mr. Chairman, Senator Feinstein, and members of the committee. My name is Hannah Smith, and I am senior counsel at Beckett. Our firm is dedicated to protecting religious liberty for people of all faiths. As Judge Gorsuch has said, religious liberty, quote, doesn't just apply to protect popular religious beliefs. It does perhaps its most important work in protecting unpopular religious beliefs, vindicating this nation's long-held aspiration to serve as a refuge of religious tolerance, end quote. To prepare for this hearing, I have reviewed all 40 cases related to religious liberty in which Judge Gorsuch either wrote an opinion or cast a vote. My assessment is that Judge Gorsuch, as an Associate Justice of the Supreme Court, would be a jurist committed to protecting this vital freedom. None of his religious liberty opinions has ever been reversed by the Supreme Court. In fact, every time the Supreme Court reached the merits in one of these cases, it vindicated Judge Gorsuch's position, even where he had dissented. An examination of these cases reveals that Judge Gorsuch is also a remarkable consensus builder. When he sat together with judges who were appointed by a Democratic president, those judges unanimously agreed with him in 80% of those cases. Overall, he was part of a unanimous decision almost 90% of the time, and when he actually authored the religious liberty decision for the court, he produced a unanimous decision every single time, 100%. This is a striking record of coalition building in an area of jurisprudence that can be quite contentious. I'll focus my remarks on 2 areas. First, Judge Gorsuch's prisoner cases, and second, his decisions involving the Religious Freedom Restoration Act. First, Judge Gorsuch has demonstrated repeatedly that he applies the law fairly to protect religious minorities and incarcerated persons, some of the most politically powerless in our society. For example, in Yellow Bear against Lampert, Judge Gorsuch addressed a case where a Native American prisoner had requested access to a sweat lodge for religious purposes. For a unanimous panel, Judge Gorsuch authored an eloquent opinion in which he said, quote, "While those convicted of crime in our society lawfully forfeit a great many civil liberties, Congress has repeatedly instructed that the sincere exercise of religion should not be among them, at least in the absence of a compelling reason," end quote. Here there was no such compelling reason. Judge Gorsuch recognized that especially in the prison context, it is, quote, "easy for governmental officials with so much power over inmates' lives to deny capriciously one more liberty to those who have already forfeited so many others," end quote. Therefore, he wrote that the government must prove it has a good reason for denying religious liberty by offering much more than the government's, quote, "bare say-so," end quote. On this point, Justice Sonia Sotomayor quoted Yellow Bear in her concurrence in another prisoner case, Holt against Hobbs. There, a unanimous Supreme Court ruled in favor of a Beckett client, a Muslim prisoner who sought to grow a religiously required beard. In two other prisoner cases, Judge Gorsuch voted in favor of a Muslim prisoner seeking access to religiously required meals and reversed a lower court decision failing to adequately consider a pro se prisoner's request for a kosher diet. Second, regarding his RFRA cases, in Hobby Lobby and Little Sisters of the Poor, the government tried to force religious ministries and family-owned businesses to change their health plans in a way that would violate their faith or else pay millions of dollars in IRS penalties. Applying RFRA, Judge Gorsuch voted in favor of the religious objectors, and the Supreme Court vindicated his position in both cases. Now, some have tried to frame these cases as an irresolvable conflict between religious liberty and women's rights. Not so. In the Little Sisters case at the Supreme Court, the government conceded that it could still achieve its interests by allowing women to access contraceptive services on the government's own exchanges, through another government program, or through other insurance plans. The government's concessions exposed an important truth. No real conflict existed between contraceptive access and religious liberty. In closing, Judge Gorsuch has a consistent record of carefully applying the relevant statutory and constitutional provisions, as well as governing precedents, without regard to a particular ideological outcome. His jurisprudence demonstrates an even-handed application of the principle that religious liberty is fundamental to freedom and to human dignity, and that protecting the religious rights of others, even the rights of those with whom we may disagree, ultimately leads to greater protections for all of our rights. Thank you.
Thank you very much, Chairman Grassley and members of the committee. It is an honor to appear before you. My purpose here today is to not pass judgment on Judge Gorsuch, but rather to discuss the subject of originalism and constitutional interpretation. The term originalism is new, dating back essentially to the 1980s, but it has not had only one meaning. At first, it was said to be original intent. Then it was changed to original public meaning. Then it was changed by some to original public meaning abstracted to allow for technological change. Then it was changed by others to say semantic meaning that might be completely different from the common public understanding. Nevertheless, despite their lack of consensus on what originalism means and what the theory requires, those who support the theory argue that originalism should be the governing mode of constitutional interpretation. First, they suggest that originalism promotes fealty to a written constitution and is therefore consistent with the framers' design. But the early courts did not see that way. Chief Justice John Marshall wrote in McCulloch that we must never forget it is a constitution we are expounding, intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. This means that constitutional interpretation is to give meaning and substance to enduring principles over time in new contexts. The fact that the framers did not envision this approach is also evidenced in the text of the Constitution, which uses very broad words such as freedom of speech, equal protection, due process of law. Those terms are not conducive to fixed meaning, and the framers likely intended that they would be interpreted and given context over time. Third, the framers came from a common law tradition. They understood that law changed to adapt to new circumstances. It is incorrect to suggest that that was inappropriate for that to do so because the framers knew otherwise. And finally, the framers were visionaries. They were not concerned only with addressing the issues of the day. They were concerned with setting forth broad principles that would guide future generations. The irony of originalism is that while it purports fealty to the framers, it actually demeans their framers' enterprises because it suggests they were more concerned with solving the problems of 1787 than in developing a constitution that could solve the problems of 2017. Originalists also err when they suggest that their theory limits the ability of courts to insert their political preferences, at least the way originalism has been practiced by conservative jurists. For example, there is no originalist theory that can support striking down federal affirmative action, as the conservative court did in Adirondack. The text of the 14th Amendment's Equal Protection Clause does not even apply to the federal government, and history during that period indicated that there were special programs that advantaged only African Americans. Originalism does not support Citizens United. The framers did not give much credence to corporations. They distrusted them. They were very limited charters. It does not support the expanded property rights that exist in the regulatory takings doctrine. And it's worth notice that Justice Scalia, when he wrote on that, suggested those cases were supported not by text or history, but by constitutional culture. Now, in my written arguments, I suggested some results that originalism might lead to that would be troublesome. The end of one person, one vote, the overruling of Brown, the idea that there would be no equal protection for women, the abolishment of the United States Air Force. Now, to their credit, many originalists will not go that far, would not take us back to the way of life of the 19th century, and some have gone out of their way to argue that Brown can be reconciled with originalist principles, which would be news to those who drafted the 14th Amendment and also segregated the schools of the District of Columbia, and would also be news to the Brown court itself, which looked for original spaces and couldn't find it, and expressly disavowed originalism as the basis for the holding in that decision. Now, but what does this say about originalism? I think it suggests two things. I think it suggests that originalists know in their hearts that originalism is fundamentally at odds with who we are as a nation. And secondly, it also demonstrates that originalism can be used to manipulate the particular results that you want to get to, so therefore does not give the fixed meaning that those who support originalists say that it does. Originalism then is a doctrine of false promises. It suggests a fealty to the framer's design when it is actually antithetical to the framer's vision. It purports to offer a jurisprudence with fixed and predictable results when its application is nebulous and variable. It claims value neutrality when it has been erratically deployed in order to achieve specific results. Certainly, text and history are important in constitutional interpretation. But the claim that constitutional interpretation should be controlled only by history and text was one that was rejected in McCulloch versus Maryland in 1819. We should learn that lesson.
Mr. Chairman, members of the committee, thank you for the opportunity to testify today. I'm a professor of law at Vanderbilt Law School, and I had the honor to clerk for Judge Gorsuch from 2007 until 2008. I am here today to enthusiastically support his nomination to the Supreme Court. Judge Gorsuch is a brilliant, fair, principled, and independent jurist. He is also the epitome of a gentleman. You will never in your life meet a kinder or more charitable public servant. One of the biggest risks a judge takes each year is inviting a few recent law school graduates into his or her chambers. Judges use law clerks as sounding boards for ideas, to spot flaws in arguments, including their own, and to find and help analyze precedent. This requires a judge to put quite a bit of faith in these recent law school graduates, and it requires them to invest quite a bit of time in teaching these recent law school graduates to be competent assistants and competent lawyers. More than that, though, working side by side in close quarters every day for a year or more makes the relationship between a judge and his or her clerks especially intimate. Judges thus often become the most important mentors young lawyers have. This mentoring role is not the most important that judges play, but it does provide a window into a judge's temperament and their approach to the law. I could not have hoped for a better mentor than Judge Gorsuch, and the country could not hope for a better teacher for its brightest legal minds. I could say a lot about Judge Gorsuch, about how he welcomes his clerks to Colorado and into his family, about how he hosted a birthday party for my one-year-old son in chambers when we didn't know anybody in Colorado. I could talk about his love of being a lawyer, the joy he takes in the back and forth of legal argument, or his concern for the integrity of our judicial system. But instead, I want to spend my time today talking about what Judge Gorsuch has taught me about writing. By the time I arrived in Judge Gorsuch's chambers, I had been in school for about 21 years, and I had probably written thousands of pages, including most of a doctoral dissertation. But I didn't really learn to write until I worked for the judge. Through conversations, reading the judge's work, reading his careful comments on my work, I learned the importance of clarity in legal writing. The judge spends hours and many drafts on just the introductory paragraphs to his opinions. These sentences, he taught the clerks, are the most important. Lawyers need to know how the court thought the Constitution, statutes, and regulations apply to the facts of a case. But even non-lawyers, the judge taught us, should be able to understand the stakes in a court case and the basic reason a case came out the way it did. The litigants themselves deserve an explanation that does not require a lawyer to interpret. I've taken this lesson with me at each stop on my legal career. Judge Gorsuch's care for writing is important in its own right because the written word is the primary medium through which judges communicate. But the judge's emphasis on writing is part of his broader concern for the process due litigants who seek the protection of our courts. As a clerk, I had the opportunity to observe over and over again Judge Gorsuch's respect for litigants and the care he took to make sure that he fairly and fully evaluated and addressed each of their claims. I have a number of examples in my written testimony, but by way of one brief example, the federal courts receive a very high number of pro se petitions from prisoners. For many of these petitioners, the Anti-Terrorism and Effective Death Penalty Act, passed by Congress in 1996, sets a bar to relief that they cannot clear, and consequently, many courts summarily dismiss these petitions. Not Judge Gorsuch. When I worked for him, he insisted that each petitioner receive a written decision on his petition. Each inmate, he told me, is entitled to an explanation he can understand, no matter how far off the mark his claim. And to be frank, many of the claims we received were prepared without the aid of counsel and were difficult to understand. No matter, the judge reminded we clerks that the court had a duty to liberally construe, that is, to give the benefit of the doubt to those who appear on their own behalf seeking the protection of the courts. The judge's concern for fair notice also underlies his deep respect for precedent. I can recall many times that Judge Gorsuch wrote that while he might have decided a case differently, a prior panel of the 10th Circuit had already addressed the question. Indeed, I had the chance this morning to look back at the 10th Circuit decision in Andrew F., which is the case that the Supreme Court decided yesterday, reversing the 10th Circuit. And in that case, the court expressly noted that the more than de minimis standard that Judge Gorsuch had applied in Thompson is actually from an earlier 10th Circuit case in Urban and a line of cases that stretch from Urban until Thompson. I'll end by noting that in both of these instances, prisoner litigation and disabled students, Judge Gorsuch has ruled on both sides of the issue. He's come out both ways. Equally importantly, though, he has advocated for better representation for prisoners who are seeking the protection of our courts and for disabled students. Judge Gorsuch believes that access to the courts and a fair opportunity to be heard for all is a critical component of our judicial system. And with that, I will look forward to your questions.
Thank you, Mr. Meyer. Now, Ms. Phelps.
Chairman Grassley, Ranking Member Feinstein, and members of the Judiciary Committee, thank you for the opportunity to speak with you today. My name is Sandy Phillips. I am a registered Republican, a gun owner, and I live in Texas, but I now vote a straight Democratic ticket. I am a mother, and I am here to speak on my efforts to stop other families from experiencing my nightmare. I am here to speak on the gun violence that takes 33,000 American citizens' lives each year. On average, 91 Americans are killed each day, 8 of whom are children. My daughter, Jessie, was one of them. 5 years ago this July, my beautiful 24-year-old daughter, Jessica Gowie, was slaughtered in the Aurora, Colorado theater massacre, along with 11 other beautiful souls. 70 others were wounded, many with wounds that will shorten their lives. I know them. I know their struggle. I know their pain, both physical and emotional, and I understand it. My daughter went to a movie and was slaughtered. I use the word slaughtered because the killer chose to use a weapon designed for the battlefield by the military as part of his arsenal and ambushed people that could not escape. He was able to purchase 4,000 rounds of green-tip .223 high-velocity bullets over the internet without even showing his driver's license. These steel-jacketed bullets were designed to rip through bone, tissue, flesh, seats, and walls. When we sued that online seller to change their dangerous business practices, our case was thrown out because of the PLACA law. The gun lobby brags that this law was their crowning achievement because it protects the industry from being sued in civil court and denies the constitutional rights of gun violence victims to have their day in court. The night Jessie was murdered, I was texting with her. I was due to go visit her in just a few days, and we were very excited to be able to spend some mother and daughter time. The last thing she wrote to me was, "I can't wait to see you. I need my mama." I wrote back, "I need my baby girl." Minutes after that text, my phone rang. It was the young man with her that we have known for many, many years, and we think of as family. What I heard on the other end of the phone changed our lives forever. I could hear horrific screaming. I asked what was wrong. He said that there had been a shooting and it was random. I asked if he was okay. He said, "I think I've been shot twice." At this point, I grew alarmed, since he was the one calling and not my Jessie. I said, "Where's Jessie?" He answered, "I'm sorry." I asked, "Is she okay?" And he said, "I tried." I said, "Brent, oh God, please tell me she's not dead." And again, he said, "I'm sorry." Brent is a firefighter and a paramedic, so I knew at that very moment that my daughter was gone. I started screaming, I'm told, but I have little memory of my husband catching me as I collapsed on the floor. Our little girl had been hit 6 times with the .223s that sprayed the theater in mere seconds. One bullet tore through her leg and entered into the other leg, making it impossible to escape. 3 more ripped through her abdomen. 1 hit her clavicle and shattered it. And 1 exploded through her left eye, leaving a 5-inch hole that blew her brains onto the theater seats, floor, and people. I live with that image every day of my life. This preventable pain and suffering of victims and survivors has changed my life. I can no longer remain silent on the sidelines. Our Second Amendment begins with the phrase, "a well-regulated," but guns are not well-regulated. Our lack of strong federal laws let people who should not have them acquire guns too easily. People like Jesse's shooter, who showed clear signs of severe mental illness that made him dangerous to himself and others, was still able to get his hands on military-style weapons and over 4,000 bullets he bought for his attack. Since this shooting, Colorado has put restrictions on the kind of magazine he used and passed new background check laws. But over the past few years, a small number of extremists have been pushing courts across the country to accept and endorse a gun lobby-backed radical version of the Second Amendment that would call into question basic public safety law like those in Colorado. This version is the one that Justice Scalia rejected, understanding the Second Amendment is not unlimited. As a mother and an American, I believe it is critical that any Supreme Court justice understands this as well. Cases pushing these radical views could make their way to the Supreme Court in the months and years to come. This committee must know: does this nominee believe the Second Amendment has limits? Does this nominee recognize that it does not override any other constitutional rights, like my daughter's right to live in a safe community? Does this nominee understand that as times change, laws must change, and responsible regulations to protect communities from gun violence have been recognized as and are constitutional and necessary? To be confirmed, any Supreme Court nominee must answer these questions clearly and convincingly. If not, the public safety is at risk. Thank you for the opportunity to speak with you today.
Thank you, Mr. Chairman, and thank you to the committee for having me here today. I want to say, obviously, a very painful story for Mrs. Phillips and her daughter, Jessie. I think what I want to say to Mrs. Phillips and to the members of this committee is that Judge Gorsuch, I've known him for 13 years. Judge Gorsuch is the kind of judge that Mrs. Phillips and that Jessie would want on the bench. He's the kind of judge that applies the law fairly and even-handedly to all litigants before him. He's the kind of judge that doesn't rule based on a policy preference or a preference for an outcome, but on the law as it's written by the members of this body, the Constitution our framers wrote. He's the kind of judge that applies the law in the way we want the law to be applied. He's a judge's judge. I've known Judge Gorsuch since he was a private practice attorney at a small law firm here in Washington, D.C. I then followed Judge Gorsuch to the Justice Department in a different office, but I saw him there as a senior Justice Department official. I then went with him to the 10th Circuit when he was confirmed to the bench and spent his first 4 months with him on the bench as he became a judge. I watched him transform from a passionate, strong advocate for his clients into a passionate, strong advocate for justice under the rule of law. He's the kind of man that cares about people, that cares deeply about his family, his friends, the parties that appear before him. He feels what the litigants before him feel, and he applies the law fairly to each and every one of those litigants. Today we've heard from a lot of individuals on this panel about what Judge Gorsuch, if he were to confirm by this body to the Supreme Court, may or may not do on the court. But what I would direct you to is his real record in the 10 years he's been on the bench. This is not a judge that a short period of time on the bench where we can't tell what kind of judge he's going to be. We can look at his record and determine exactly what kind of judge he's going to be. Now, over the last few days, you've heard about a handful of cases where people feel like he hasn't ruled for the little guy. Well, let me tell you about some of the cases where he has ruled for the little guy. Avila v. Jostens, where he voted to allow a Hispanic employee to bring a claim of race discrimination, reversing district court. Dasgupta v. Harris, where he voted to deny qualified immunity to a university official accused of discriminating against an Asian American professor. Orr versus City of Albuquerque, where he held that 2 female police officers could bring pregnancy discrimination claims and reverse the district court there also. Gadd versus Kansas State, where he allowed a professor's sex discrimination claim to proceed. All-state sweeping, where he allowed 2 female contractors to bring a gender bias claim against a male Denver airport employee. Chapman versus Carmike Cinemas, where he voted to reverse the district court and allowed a female employee who had been sexually assaulted to bring a hostile work environment claim against her corporate employer. Dasa v. Wynn, where he voted to allow a female employee to sue her employer for gender discrimination. WD Sports, where he reversed the district court and allowed a female employee's sexual harassment suit to proceed to trial. Eisenhower v. Weber County, where Judge Gorsuch voted to allow a female court employee to bring claims against a male judge who had sexually harassed her. Original Bolts v. Colvin, where Judge Gorsuch voted to reverse the district court's dismissal of a female worker's hostile work environment claim. Lauber versus City of New Cordell, where Judge Gorsuch ruled that a female employee could sue a city government for sex discrimination, again, reversing the district court. In case after case after case, Judge Gorsuch has applied the law fairly and even-handedly to litigants before him. Yes, it's true. In the occasional cases, the 3 or 4 you heard about over the last few days, Judge Gorsuch has ruled for a corporate employer. But time and time and time again, he's ruled for the little guy, the woman, the sexually harassed, the discriminated against, the disabled. So the notion somehow that Judge Gorsuch is not capable of being an even-handed, fair judge, the kind of judge that Mrs. Phillips and that Jesse deserve, is absolutely wrong. He is a judge's judge. He will be a credit to our nation and to this body, and he should be confirmed swiftly. Thank you, Mr. Chairman.
Thank you. I'm going to call on Senator Coons because he has another assignment.
Thank you very much, Mr. Chairman. I'd like to thank this entire panel. I'll take just a few minutes and ask 2 questions, if I might. Ms. Warbelow, over the course of the entire several days of hearings, Judge Gorsuch repeatedly said that he respects precedent and follows settled law. And I questioned him about critical cases, Casey, Lawrence, Obergefell. The judge also wrote that judges should, and I quote, apply the law as it is, focusing backward, not forward, and looking to text, structure, and history to decide what a reasonable reader at the time of the events in question would have understood the law to be. But these 3 critical cases, as I questioned him about, Casey, Lawrence, and Obergefell, don't merely look forward. They applied a more inclusive and modern principle of liberty and its understanding to protect the right to privacy, relationships, and marriage. Can originalism, as Judge Gorsuch defined it, protect the freedoms the Supreme Court has now recognized for LGBT individuals based on the Due Process Clause?
If we press the pause button at the exact moment in time when either the Constitution was written or any single statute was written, we miss the broader context and how it affects and applies to people's lives. It's not a surprise to anyone in this room that in the 1700s, LGBTQ community was a stranger to the law. And if we continue to advocate for a view of the Constitution that is stuck in that time period, we will always be strangers to the law. And Judge Gorsuch himself made very clear that he thought the LGBTQ community should only have recourse through the legislature, that marriage equality was not appropriate topic for the courts and should be left solely to the legislatures. But the role of the court is to recognize that minority populations are often disadvantaged when it comes to the tyranny of the majority. And a good justice looks to how people's lives are affected and how the rule of law will apply in the day-to-day.
Thank you, Ms. Warbelow. Ms. Miller, there's been a lot of discussion in the course of these hearings from President Trump's campaign promise about what kind of justice he might nominate through questioning of Judge Gorsuch this week. And the potential overruling of Roe versus Wade seems to always hover in the middle distance in these hearings. I'm concerned, however, that there's many ways that courts can and would limit women's access to health care without explicitly overruling Roe. And as you heard perhaps in my questioning of Judge Gorsuch, I had questions for him about what his standard of complicity meant and where it came from and what its consequences would be. In what ways could the court limit access to reproductive care without overturning Roe? And what does Judge Gorsuch's record say to you about how he might approach these cases?
Thank you for the question. I'm very concerned about his record and his ability to set aside personal beliefs and rule in a fair-minded, independent way. What we have seen since 2010, like I referenced in my statement, is 330 laws that have been passed to restrict women's access to abortion services, even with Roe being stable. We've seen waiting periods. We've seen requirements that close physical plants. We've seen really women, with undue burden having to travel hundreds of miles and encounter, lots of obstacles. So what we really have is a situation where a right exists on paper, but it's not the ability to access it in the real way people live their lives.
Ms. Miller, if I might, though, just to clarify, you're talking about legislatures acting. Why isn't that an appropriate venue, and what's the court's role in this?
Well, what you might, in our case, Whole Woman's Health, we brought to the Supreme Court, we were able to illustrate that legislators went too far, and the court ruled in our favor, saying you can't just pass laws willy-nilly to block people's access. They need to be substantiated by medical fact and medical evidence, and that that it put an undue burden on women's ability to access their rights to privacy and their right to safe abortion as guaranteed by Roe.
Thank you. I'd like to thank you both, and I appreciate your consideration, Mr. Chairman, and the opportunity to talk with you both about legitimate concerns about the scope of the right to privacy and its impact on people's lives. Thank you.
Thank you.
Thank you, Mr. Chairman. Let me ask Mrs. Smith some questions. I want to thank you for your work defending our first freedom, religious freedom. As you know, I'm one of the authors of the Religious Freedom Restoration Act, one of the prime authors, and also I'm the author of the Religious Land Use and Institutionalized Persons Act. Now, these statutes make it difficult for the government to substantially burden the exercise of religion. And your organization, the Beckett Fund, uses these statutes to vindicate the fundamental right to exercise religion for men and women of many faiths. Your written testimony quoted from Judge Gorsuch's concurring opinion in Hobby Lobby Stores versus Sebelius that RFRA, quote, does perhaps its most important work in protecting unpopular religious beliefs, vindicating this nation's long-held aspiration to serve as a refuge of religious tolerance, unquote. In Hobby Lobby, Judge Gorsuch's court concluded that RFRA can apply to a corporation. My guess, however, is that in your practice, the most frequent use of these statutes is to defend the individual, the little guy, if you will, since we've had talk about that we've heard so much about. It is to defend the weak and the powerless and the disfavored. Now, I have two questions about Judge Gorsuch's record in this area. First, do any of his decisions or opinions in such cases go beyond interpreting statutes the way Congress enacted them and implementing those statutes as Congress intended? And second, how critical is it to faithfully interpret and apply statutes like these when it might be controversial as well as when the plaintiffs are more sympathetic?
Thank you very much for that question, Senator Hatch. So your first question was, are there any decisions that go beyond the correct interpretation of these statutes in Judge Gorsuch's 10 years on the bench? And I've looked at a lot of his opinions that he has written where he has interpreted RFRA and its sister statute, RLUIPA, which you also mentioned. And I think his jurisprudence very clearly shows that he understands the limits of these statutes. He understands the balancing test that Congress put into these statutes, and that he has found in favor of religious parties some of the time, but he's also found against parties who are religious litigants in other cases. Hobby Lobby and Little Sisters are two examples where he was in favor of the religious objectors, and he found that there was a substantial burden on their religious exercise in those cases. And the government even ultimately conceded that they had alternative ways to meet their interests without forcing these religious objectors to violate their faith. And I think, those two cases show very clearly that there was no conflict to begin with between religious liberty and women's rights. But there's some other cases where he has held that the religious parties were either insincere or that they didn't suffer a substantial burden under RFRA. There was one case I spoke about in my written testimony where a couple had set up a fake church created to distribute marijuana, and they sought the protection of RFRA for their drug running. And Judge Gorsuch said, sorry, that's an insincere claim, and RFRA is not going to protect you there. So I think, Judge Gorsuch's ability to really require the government, as he has said over the last few days, to square its corners, to prove its case, to show that it has a good justification for what it's doing, along with his ability to really impose and recognize these reasonable limits on religious liberty where there are meritless claims, shows that he has a very balanced and thoughtful approach to applying these statutes, as he has done so over the last 10 years on the 10th Circuit. And how critical is it that these statutes be faithfully interpreted and faithfully applied? Well, it's absolutely critical. And as you know, Senator, RFRA has been used to protect religious minorities around the country. And certainly many of Beckett's clients are religious minorities. I'm thinking here of Pastor Soto, who is a pastor of a Native American church out in Texas. And the government created Operation Powwow and went in undercover and invaded his religious circle to confiscate eagle feathers. Now, it was because of RFRA, and I might also add the Hobby Lobby decision, which the court cited, that he was able to get those precious eagle feathers back and use them in his religious ceremonies. It was also RFRA who helped another of Beckett's clients, Captain Simmer Singh, who is a devoted Sikh, to be able to ask the Army to give him an accommodation so that he could wear a religious beard and a turban according to the requirements of his faith. And eventually, he was able to get that accommodation thanks to RFRA. And then eventually the Army was actually willing to change its regulations so that now all Sikhs can faithfully serve in the Army and not have to deny their faith in doing so. So I appreciate the question, Senator. I think it's a really important point that we make here, that RFRA and RLUIPA protect religious minorities around the country and do this vital work of preserving religious freedom.
Well, thank you so much.
Senator Franken.
Thank you, Mr. Chairman. Ms. Phillips, thank you for your testimony honoring your daughter.
Thank you very much.
So sorry for your loss.
Thank you. I appreciate that. I'd also like to ask Senator Grassley if he would please make note in the record that this gentleman next to me does not speak for me or my dead daughter.
You just made that point, and we accept it.
Okay, Ms. Clark, thank you for being here today. I'd like to talk about voting rights. Now, as Judge Gorsuch and I discussed yesterday, the Supreme Court's Shelby County decision gutted the preclearance provision of the Voting Rights Act, which required certain states with a history of engaging in discriminatory practices at the polls to get the federal government's approval before making changes to the voting laws. Shelby County struck down the provision that determined which state